So I wanted to start my presentation by briefly framing my reasons for choosing to research the question that you see. How does the legal relationship between asserted Crown sovereignty and Indigenous pre-existence shape reconciliation? So speaking broadly, three things drew me to Aboriginal law, and the first two are the moral imperative and the excitement of learning about an area of law that's going to evolve a lot over the course of my career. But the third, and the one that was probably the most unexpected when I came to law school, is how the case law and learnings from Indigenous guest speakers and from John Burroughs actually opened me up to new ways of seeing the world around me. And I can remember a similar moment during my undergraduate degree in political science that I learned about how institutions are the real mark of democracy, not elections. And that realization, which feels simple in retrospect to me now, actually reshaped my worldview. And I felt the same kind of shift learning about how Indigenous conceptions of law and sovereignty in the land can differ from what I grew up with, but also be equally legitimate and defensible. And from where I'm sitting, this also seems simple in retrospect, I guess, but I feel grateful for it. And learning this made me want to look more closely at how courts have attempted to reconcile asserted Crown sovereignty with Indigenous pre-existence on this land, which I see as being fundamental to the ongoing process of developing Aboriginal law that's principled and that's honest. So Desautel and the Queen, which was the case that I studied with Professor Wilkins at the Aboriginal Law Factum this year, provided an opportunity to look more closely at these issues, and specifically through one argument that the Crown kept on making in its factums, which was about sovereign incompatibility. To briefly explain some of Desautel's facts, so it's a test case led by members of an Indigenous collective, the Sinixt, living on the Colville Reservation in Washington, D.C. And they are seeking an Aboriginal right under Section 35(1) of the Constitution Act to hunt in their traditional territory in British Columbia. And this case is novel for a few reasons, which made it really fun to study. It's novel because of how continuity, citizenship, and border issues all impact the Section 35 analysis in different ways. But one of the novel arguments in particular struck me, and that was how the Crown, in several ways through 4 factums, submitted that the hunting right sought by Mr. Desautel, which the Crown characterized as including a mobility right to cross the US border, was actually incompatible with Canadian sovereignty. And I've included a couple of their submissions in the PowerPoint, so you can just see some examples of the Crown's reasoning on this topic. So in making these arguments, the Crown cites what I saw and perceived as Westphalian European theories of international law as a reference for certain types of activities that are core to sovereignty. And they characterize these types of activities or claims as having been extinguished by the assertion of Crown sovereignty, which would mean that they're unavailable to Indigenous collectives who are seeking rights now. Though they note that sovereign incompatibility is a different argument than an extinguishment argument, which requires clear intent. And I think because these classes involve a lot of discussion, I just found myself getting bothered by this argument in a different way than I get bothered sometimes by arguments that are frustrating or that feel unfair from a moral justice standpoint. Because to me, sovereign incompatibility just didn't feel like it fit with the alternative, like with the internal logic of the Van der Peet test, and also of how Section 35 has been interpreted by courts to date. In my mind, so when thinking about and trying to consider more deeply the validity of the Crown sovereign incompatibility arguments, I found that they would be related to how Crown sovereignty is supported in Canadian law. So the first part of my research essay, after examining the reasoning in Desautel factums more closely, turned to the Canadian common law's justifications of Crown sovereignty throughout the case law. So you can probably see from my PowerPoint's kind of crude breakdown of the case law that I classified court statements on Crown sovereignty into 2 different stages. And in the first stage, noting that contact occurred prior to this, in 1763, Britain issued a document called the Royal Proclamation, and it asserted British sovereignty on what is now Canadian territory. Then St. Catharines Milling was a leading Aboriginal rights case that followed in 1888, holding that Aboriginal rights stemmed only from this proclamation, that it was their source. In holding this, the court found that the proclamation provided Indigenous people with a limited usufructuary right to their territory, but that, make no mistake, the underlying title was vested with the Crown. This line of case law unjustly limited Aboriginal rights and failed to explain how the Crown was able to legitimately acquire sovereignty on the whole territory it was asserting over. But its limitation on Aboriginal rights to the four corners of the proclamation, I think, logically follows if you accepted that the proclamation was the source of Aboriginal rights. And then this state of affairs shifted in the jurisprudence, starting with Calder in British Columbia. The court in Calder acknowledged for the first time, to quote Justice Judson, that when the settlers came, the Indians were there, organized in societies and occupying the land as their forefathers had done for centuries. This is what Indian title means, and it does not help one in the solution of this problem to call it a personal or a usufructuary right. But even as Judson rejected the previously accepted source of Aboriginal rights, he failed to provide an alternative justification for their limitations, except to say that they continue to be subject to Crown sovereignty. And you can see from the Sparrow quotation in the PowerPoint, this reasoning carried over into Section 35 jurisprudence as well. Now, this isn't to say that the courts have been completely silent on the subject of how the Crown acquired sovereignty. But in my opinion, their reasoning has never satisfied. In the landmark case, Silcotin, the court held the doctrine of terra nullius, that no one owned the land prior to European assertion of sovereignty, never applied in Canada, as confirmed, in fact, by the Royal Proclamation. The Aboriginal interest in lands that burdens the Crown's underlying title is an independent legal interest. In the same paragraph, however, they also state that at the time of assertion of European sovereignty, the Crown acquired radical or underlying title to all the land in the province. So here the court has steered itself into a bit of a corner because Indigenous rights now exist independent of Crown sovereignty, but that sovereignty still remains legitimate over lands that was never conquered, ceded, or subject to the doctrine of discovery, which we are told. So the Vanderpeet test and related modifications, permitting Indigenous collectives to claim the benefit of Section 35 based on pre-existing occupation factors, have negotiated an uneasy truce with what John Burroughs calls the legal vacuum at the heart of Aboriginal law. To be clear, courts have accepted that the Crown has de facto sovereignty. The Supreme Court in Haida Nation in British Columbia said exactly this, reasoning that the honor of the Crown arises in turn from the Crown's assertion of sovereignty over an Aboriginal people and de facto control of land and of resources. But the legal justification remains unspoken, leaving the content and then the limitations of Crown sovereignty unannounced. Speaking to this, Burroughs writes about Silcotin. It needs to be acknowledged that Silcotin title also imposes significant limits on the Crown's underlying title. In this spirit, the court wrote that Crown title was burdened by the pre-existing legal rights of Aboriginal people who occupied and used the land prior to European arrival. Additionally, the content of the Crown's underlying title is what's left when Aboriginal title is subtracted from it. These are substantial subtractions from the Crown's estate. They likewise legitimately constrain Crown sovereignty, because these limitations substantially reduce the ability of the Crown to control, use, or benefit from land subject to Aboriginal title. However, the Crown still has a paramount legal interest in Aboriginal title lands, and this is where the judgment becomes more problematic when considering whether the court has really rejected the doctrine of discovery. I think that there are many reasons that courts are likely reluctant to delve into this issue. whether it's even possible for the Supreme Court, for example, to undermine its own jurisdiction by questioning the legal basis of Crown sovereignty. But regardless of the particular reasons, I argue that this emptiness at the heart of de jure Crown sovereignty has troubling implications for how that sovereignty continues to be exercised in relation to Aboriginal rights. And particularly so, I think this problem arises if the Supreme Court affirms that a sovereign incompatibility requirement applies to the Section 35 analysis. So with the uncertainty surrounding the legal basis for Crown sovereignty in mind, we ask, where does that leave us on the issue of sovereign incompatibility? The doctrine of sovereign incompatibility has not gotten a lot of attention and care in the case law, likely for the reasons already mentioned. Justice Binney's concurrence in Mitchell is one of the most comprehensive statements on it by the Supreme Court, and it offers one view that the court could take in Desautel. The majority in Mitchell mentions sovereign incompatibility, but declines to make an express ruling on the source or the extent to which it could be incorporated into the Van der Peet test. In what Carey would probably refer to in class as a case of the court trying hard, Binney lays out his theory of sovereign incompatibility in a concurrence in great detail. He reasons that there are certain aspects of Canadian sovereignty, like its monopoly on the use of legitimate force, for example, that are integral to its sovereignty and thus will limit the scope of Aboriginal rights, even if those rights have not been expressly extinguished by the Crown. However, he doesn't provide a test for evaluating those rights. In his reasons, Binney invokes the language of reconciliation as actually a kind of blended sovereignty and says that this is a justification for sovereign incompatibility. In one instance, he remarks about Chief Mitchell that Mitchell lives with a foot simultaneously in two cultural communities, each with its own framework of legal rights and responsibilities. As Canon Takaran, he describes learning from his grandfather, the spiritual practices of the people of the Longhouse, whose roots in North America go back perhaps 10,000 years. Yet the name Michael Mitchell announces that he is also part of modern Canada who watches television from time to time and went to high school in Cornwall. As much as anyone else in this country, he is a part of our collective sovereignty. Binney discusses this notion of a shared sovereignty a second time, saying that if the principle of merged sovereignty, articulated by the Royal Commission on Aboriginal Peoples, is to have any true meaning, it must include at least the idea that Aboriginal and non-Aboriginal Canadians together form a sovereign entity, or the measure of common purpose and united effort. So in his concurrence, Binney conflates the concepts of reconciliation and emerged sovereignty, and I argue that this approach would harm reconciliation. The Crown's lack of a coherent theory of sovereignty, or a principled legal basis for this notion of a collective sovereignty and the boundaries within which it operates, means it cannot advance a robust legal test in favor of barring claims using sovereign incompatibility. Though the Crown in Desautel argues otherwise, in practice, sovereign incompatibility would act as a threshold extinguishment test, with a lower bar based on intuition over logic. And I think that this is evident from the type of language used by Binney in his concurrence. He tries, but he's unable to articulate a specific type, a texture, or a quality that would make a certain right incompatible with Canadian sovereignty as it's currently understood in relation to Aboriginal rights, other than it's likely to be something that the Crown considers core, something that feels intuitively uncomfortable, which arguably might also include the rights most highly sought after by Indigenous collectives. The Crown factums in Desautel similarly struggle to qualify how the sovereign incompatibility bar would actually operate. They assert a few things. They say it would be rare in practice, that it's based on precepts of international law, that it's principled because it only would protect core activities, and that most importantly, it should apply to this case and it should apply to a mobility right. But there is no mention of why these types of activities practiced by Indigenous collectives, who could meet the Vanderpeet test otherwise, should be accepted for reasons other than under the infringement and justification framework, which I see as being perfectly well suited to deal with examples like Binney's war right or the mobility right to cross the border at issue in Desautel. To this end, Mr. Desautel's arguments in his British Columbia Court of Appeal factum highlight the same issues that Binney's concurrence does in Mitchell. Mr. Desautel submits, treating sovereign incompatibility as a standalone question at the rights definition stage is also inconsistent with the purpose of Section 35(1), in that it presumes that the reconciliation of the prior occupation of Aboriginal peoples with Canadian sovereignty has already been achieved. Mr. Justice Binney's analysis is premised on the idea that it is inappropriate to recognize rights which supersede Canadian sovereignty, because at the assertion of sovereignty, Aboriginal and non-Aboriginal people together formed a sovereign entity. At least one scholar has argued that this approach is flawed, as it presumes that there is no need for Aboriginal pre-existence to be worked into the fabric of Canadian society. And so it dispenses with actually the very purpose of Section 35(1). An endorsement of sovereign incompatibility as a threshold test by the Supreme Court in Desautel would increase the incoherence in the case law that does exist, that of Indigenous pre-existence on this land and de facto Crown sovereignty, by undermining the boundaries and the applicability of the Vanderpeet test as the workaround that has been developed to avoid confronting uncomfortable truths. In practice, Binney's merged or collective sovereignty describes a further assimilation of Indigenous people into Canadian law, not reconciliation. When thinking about this part of my syrup, I'll note it always feels easier to know what reconciliation is not, as opposed to the challenge of articulating what it would be. But with that said, I charted 3 tentative paths forward that I argue would further the process of reconciliation, not punt it down the road. The first path, and the most straightforward, would be for the Supreme Court to reject sovereign incompatibility and to continue to assess Aboriginal rights within the existing frameworks we have now. The second, more radical path would be for the court to additionally affirm that Section 35 of the Constitution limits Canadian sovereignty, minimizing the issue of sovereign incompatibility. The federal court case Watt and Liebelt is instructive in this regard. There, the court wrote, Canada has by its constitution limited the exercise of governmental powers which may be inherent as a sovereign state. Section 35 of the Constitution Act now guarantees existing Aboriginal rights not previously extinguished, and thus carries the corollary that no agency of the state can after 1982 extinguish those rights. As long as the Constitution remains unamended, Canadian authorities are subject to this limitation on what would otherwise be an incident of sovereign power. In fact, in adopting Section 35, Canada has exercised its sovereignty by establishing a hierarchy of rights exercisable in Canada, a hierarchy that can only be altered by another exercise of sovereign power, namely the amendment of the Constitution. And if the courts were to take this position, future harmful sovereign incompatibility arguments could be prevented. Now, my third and most radical proposition would be to articulate a more honest legal basis for Crown sovereignty in Canada. The Supreme Court in Haida Nation in British Columbia reasoned, reconciliation is not a final legal remedy in the usual sense. Rather, it's a process flowing from rights guaranteed by Section 35(1) of the Constitution Act 1982. This process of reconciliation flows from the Crown's duty of honorable dealing towards Aboriginal people, which arises in turn from the Crown's assertion of sovereignty over an Aboriginal people and de facto control of land and resources that were formerly in control of that people. I think that an explanation for de facto Crown sovereignty would probably be deeply awkward and highlight uncomfortable truths about Canada and Canadian identity. So I do really appreciate the reasons why it hasn't been done, but I do think that it's possible, and that I think it would be helpful to more fully describe the source, character, and boundaries of Canadian sovereignty, whether it be by sword, pen, or something else. One scholar, Michael Adams, proposes a novel encroachment theory that could be suitable, though there are many options available. Under this theory, Indigenous people were essentially worn down by an influx of immigrants, he says, of disease, of military conflict. He calls it a sort of invading culture, and argues that it accommodates the continued assertion of Aboriginal sovereignty in the face of Crown sovereignty, but also acknowledges the reality. Whether this theory of sovereignty is the best option or the most descriptive should be debated. For example, it could be fair to press the discovery doctrine instead. Either way, though, I argue that through a theory or combination of theories, addressing this incompatibility in the case law will move us away from more unprincipled arguments like that of sovereign incompatibility and towards a better state of reconciliation of our realities currently with our future aspirations for the relationship between settlers and Indigenous people on this land. Thank you. If there are any questions.
Hello.
Hi, I just unmuted Douglas. Douglas, I'm sorry, I muted you at one point because I don't know that you knew how to mute yourself.
I'm muting on my end.
Okay.
Thanks. So Kiran, that was really great. Thank you so much. Very impressive. I have one question, or maybe if you could just say more about. It seems to me that there is sort of implicit in your description, and then also the way the case law maybe plays out, an implicit sort of distinction between sovereignty in municipal law and then sovereignty in international law. And I'm wondering, like, are those the same thing, or are they different things? And if they're different, how are they different, and how does that drive your analysis of sovereign incompatibility?
Totally. So I think a few things on that front. I think essentially in practice what happened is, when colonizers were coming to North America, they were discussing amongst themselves. Like, they were using the same frameworks of like relationships between European nations at the time that we now apply to the whole world. Of like, sort of like, the Royal Proclamation stemmed from the British achieving victory over the French. So I think to use the international sort of like signifiers of European sovereignty and applying them to more complicated local situations on the ground is inappropriate, because using those types of assertions of sovereignty, which we discussed in the core course with Carrie, might not even encapsulate the type of relationship that Indigenous people necessarily have with the land or how they think about ownership. And sort of trying to argue using those international definitions in court and then apply them to something that might not be appropriate and might not recognize the situation on the ground, I think just gets us farther away from like figuring out what this relationship should be and not closer. I think it's like a way of trying to make it seem clean and simple by saying like, this is what the international community defines sovereignty as. But I think that it ignores the history that we're actually facing.
Okay, so, but doesn't that raise a question then about, it is the international community that is establishing international law, and the definition of international law as a sovereign is then set out by this community. How do we reconcile that with this, not thinking about the international law community at all, and instead just as purely municipal domestic problem.
Mhm. I think that in practice, you can still have the international law be valid in terms of the way that international relations work, but then still, like within Canadian law itself, I think like struggle to articulate a more nuanced explanation of the relationships, because I feel like under international law currently, I mean, I can't speak to this like exactly and specifically, but I feel like Indigenous rights like aren't really noted or valued. So I think that moving away from international law and like what we say there, and then saying, okay, no, we've developed a different model in Aboriginal law, the Vanderpeet test, to like try and negotiate these realities. And like this is like the analysis that we should be using. We shouldn't be, you know, thinking about what like international law says about the theory of states.
Okay, thanks.
Yeah, I don't know if that fully answers the question. It's hard to articulate, but
yeah, these are complicated and nuanced topics, so I appreciate your efforts.
I think we have time for one more question.
Kiran, you will know from reading Vanderpeet and Delgamuuk that one of the things the court is concerned about in Aboriginal rights jurisprudence is this notion of it being cognizable within Canadian law. Do you have a thought about the relationship between this notion of cognizability and the notion of sovereign incompatibility? Can things be can things fail the cognizability test for other reasons, or are the two notions essentially interchangeable?
I guess that in my opinion, to me, an element of the cognizability related to the way that the right was articulated, that it had to be that like part of it is being in a form that's recognizable by the common law, which does involve difficulties in like translating different ways of life into like, the Canadian common law system. So I would argue that they're separate. And I think that it's possible to do a better analysis for the basis, like whether you agree with cognizability or not, I think it's possible to make an analysis like according to both the common law and Indigenous perspectives, like taking those both into account in my mind is like how you're able to articulate rights and ways of life in a way that is cognizable to Canadian law. So I think in my mind, the barrier with cognizability is whether, and like it's a fair, it is a complicated barrier as well, is whether like the type of thing being articulated the Canadian law can recognize versus in my mind, sovereign incompatibility and like my analysis sort of argues that sovereign incompatibility doesn't have that same kind of perspective of both parties involved to it. And for those reasons, at least not the way that it's been articulated so far in the case law. So I do think that they're different things, and I do think that you can address cognizability issues without sovereign incompatibility.
Okay. Let me just float one more thing with you. In American law, the notion that we call sovereign incompatibility has functioned not as a strict yes or no test. You're either compatible with sovereignty or you're not. But it has operated as a means of reading down the retained sovereignty of Indigenous nations there, such that it is compatible with the sovereignty of the United States. So it shapes the sovereignty, or in our case, it might shape the boundaries of Aboriginal rights rather than deciding whether a given thing can be an Aboriginal right. Have you thought about sovereign incompatibility possibly working that way, and does it make any difference which way we think about it?
In my mind, that makes more sense. But I also don't think that we need a second way of doing it. Like, I don't know if it's useful to Aboriginal law to start incorporating sovereign incompatibility as an element of this analysis, when I think the justification infringement frameworks already sometimes read down Aboriginal law, like Aboriginal rights, in like under a different analysis, but like with a similar result. I don't know if, I think that that's a better alternative to the way that it currently operates as a complete bar, but I also don't know if it's like necessary or useful to incorporate it into the case law, regardless, even if it were in that way.
Okay, I think those are my questions for now. Thanks.
So to begin with an overview of what I've decided to write my SIRP on, I chose to look at how Indigenous knowledge has been used in federal environmental assessments. And this topic, I originally came to it because of recent amendments to the assessment framework that were made in 2019. And also because I came to law school with an interest in how scientific evidence ends up being used in legal decision-making. And then as I went through law school and took classes on Aboriginal law and Indigenous legal traditions, and started to think about duty to consult and other forms of knowledge that come into how we think about legal problems, I became interested in this idea of how different knowledge systems are understood within decisions that are made in legal systems. So this was a great way to think about that in a more specific context and see how this ends up playing out in our environmental law frameworks at the moment and how maybe it could be done better. So to give some context for the environmental assessment regime in Canada, the federal environmental assessment regime has been in place since the 80s and 90s, and Indigenous knowledge has been something that has been discussed in those frameworks as early as 1992 with the Canadian Environmental Assessment Act that was introduced then. But in that version, it was an optional thing for assessment decision makers to take into account. The language was that the assessment agency may take into account what was then called Aboriginal traditional knowledge. When the Canadian Environmental Assessment Act was amended in 2012, very similar language was used once again. Consideration of Aboriginal traditional knowledge was not a mandatory factor of consideration. It was something that could be considered and was listed separately from the mandatory factors that decision makers had to consider when assessing the impacts of a designated project on the environment. In 2019, that changed. The Impact Assessment Act now provides, under Section 22, that Indigenous knowledge provided with respect to a designated project must be considered when the now what's called the Impact Assessment Agency reviews a project. Now, this framework also makes a number of other changes to how assessment is undertaken, and I'll talk about that a little bit later. But this shift from may to must creates a space to think about how decision makers should be engaging with Indigenous knowledge and thinking about it and applying it within their decisions. Now, we haven't seen this play out yet, as the way that the Impact Assessment Act was implemented is that projects that were already underway in the assessment process will continue forward with the 2012 Canadian Environmental Assessment regime. So as of yet, the Impact Assessment website does not show any projects that have had to apply this new way of thinking, new set of factors in completion. So we don't have any final reports yet. But this also creates an opportunity to think about how decision makers should be doing this, especially because the federal government has not yet released its policy guidance document on Indigenous knowledge use. So I structured my paper in 3 sections. The first section, I look at what effective use of Indigenous knowledge in environmental assessment should look like, or could look like. And I do this by going through academic papers, but also the consultation documents that were provided to the government when it designed the Impact Assessment Act by Indigenous communities, as well as existing Indigenous knowledge frameworks that certain communities have already developed for self-government. And then I turned to applying what good use of Indigenous knowledge could look like to what we've been doing so far. And I did this with a case study of 5 environmental assessment decisions that took place or were completed in 2019 in relation to 5 mining projects across the country. And I found that even in the limited way that Indigenous knowledge was supposed to be used under the Canadian Environmental Assessment Framework, in practice, the lack of structure or understanding of how to consider Indigenous knowledge plays out in a way that ends up not even achieving some of the more limited goals that were set under the Canadian Environmental Assessment Act. And then that brings me to my final section, which is how can barriers to use of Indigenous knowledge that existed under the Canadian Environmental Assessment Act be overcome under the Impact Assessment Act? And will they be overcome at all, or could they be overcome at all? So to begin this discussion, it's important to talk about what Indigenous knowledge means. And this in itself is a bit of a complex idea. It can mean a lot of things, and governments versus communities tend to define it a bit differently. So here are a few academic and community-based definitions, but it encapsulates Indigenous communities' ideas regarding the environment that comprise a field of knowledge built up over generations based on interactions with the land. And something important about Indigenous knowledge is that it is developed through a specific methodology and has its own method and impact, and though it has limitations, and John Burroughs argues should be used in conjunction with other forms of scientific evidence, it is tested and developed through precedent of what is passed on through generations, and has its own method and integrity in that sense as well. And so in looking at what effective use of Indigenous knowledge in environmental decision-making can look like, I found that something that didn't match up in various different discussions of this topic was what we were trying to achieve by bringing Indigenous knowledge into environmental assessment. And I found that there were 3 different types of purpose that different scholars and government bodies talked about when they discussed the value of bringing Indigenous knowledge into environmental assessment. So the first I've described as enhancing evidence. So this one is what has been described most often in government policy documents relating to the Canadian Environmental Assessment Act. It also comes up a lot in scientific literature describing Indigenous knowledge, and it's the idea that there are some things that science can't observe in time, or that scientific studies don't show with enough certainty, and so Indigenous knowledge is a source of additional data that environmental assessments can turn to in order to maybe fill in the gaps or provide an alternative explanation of how adverse effects in the environment will result from a project. The second purpose of bringing Indigenous knowledge into environmental assessment is an idea of improving understanding of Indigenous perspectives. And this often aligns with ideas of consultation in environmental assessment and making informed decisions that are responsive to the interests of Indigenous parties affected by a project. And this we see in, again, the Canadian Environmental Assessment policy guidance documents on how traditional knowledge, Aboriginal traditional knowledge, should have been used under that regime, and also in the discussion paper that the federal government released alongside the Impact Assessment Act on Indigenous knowledge policies. For instance, the government mentions there that Indigenous knowledge enables federal organizations to have a more complete understanding of Indigenous worldviews, Indigenous cultures, the environment, and social health and economic conditions. And the third purpose, and this is what I would characterize as the most ambitious and perhaps the most worthwhile, is to introduce improved sustainable development decision-making. The United Nations Declaration on the Rights of Indigenous Peoples speaks to this purpose. It says that respect for Indigenous cultures and traditional practices contributes to sustainable and equitable development and proper management of the environment. John Burroughs also argues that incorporating Indigenous knowledge into governance of the environment can help improve decisions that further sustainable development, as Indigenous communities have governance structures and laws that, along with Indigenous knowledge, can provide our governments or Canadian governments with new ways of thinking about interacting with the environment in a manner that thinks about future generations rather than just the present. And so I've identified these three purposes at the beginning because it's helpful to think about them as I go through what a successful Indigenous knowledge implementation looks like, because I found that the first two tend to lead decision makers towards problematic uses of Indigenous knowledge. And in fact, probably shouldn't be the goal if we're bringing Indigenous knowledge into environmental assessment. And this comes up in kind of three main ways. So the first is that a problem that arises with use of Indigenous knowledge and impact assessments so far has been that processes of bringing that knowledge into the assessment process is highly extractive and removes Indigenous knowledge from its proper context, and as a result, improperly translates that knowledge and puts cultural assumptions from Western settler cultures onto that knowledge. So generally over the past few decades, when Indigenous knowledge has been used in Canadian and other country assessment processes, what will happen is external researchers will go into communities and conduct interviews and provide reports that compile Indigenous knowledge and provide that information to either a government body or a proponent who's developing a project. And this has been characterized as problematic, as Indigenous knowledge is not something that can be broken up into categories the same way that often scientific reporting is done. So removing that knowledge from its cultural and spiritual context loses the complexity and the full scope of what that knowledge actually is. And so to solve that problem, the Mi'kmaq Ecological Knowledge Study Protocol provides some guidance on how to improve practices of compiling knowledge for assessments. It calls on governments to provide control over knowledge to communities and ensure that processes maintain that control throughout the process, so that it doesn't get decontextualized or misused in the hands of people trying to apply it or interpret it. It also calls for researchers who understand communities specifically and have spent time in communities and understanding their relationship to the land, their history, and how that knowledge has been passed down. And also a framework for using the knowledge that respects how the knowledge was gathered, rather than breaking it down into smaller components or using it in a piecemeal fashion. And then recommendations in terms of how the proper use of that knowledge once it's getting applied. Criticisms there that I found focused highly on how Canadian or other Western systems of environmental assessment tend not to bring in the underlying governance and legal systems that go along with thinking about the environment through Indigenous knowledge frameworks, and how in order to properly bring Indigenous knowledge into governing the environment in our frameworks, we need to also implement improved integration of Indigenous governance into environmental assessment. Deborah McGregor argues that our assessment processes right now are very rooted in piecemeal assessments of individual factors, say impact on fish, impact on water, impact on habitat. And in order to capture the dynamic perspective of environmental systems, we need to have a more integrated approach to looking at impact. Don Burrows goes further and discusses how we need to have an effort to shift underlying perspectives as well as the overt frameworks of assessment, as the moral and legal philosophies of decision makers actually impact and are a barrier to implementing Indigenous knowledge in assessments, and points to the way that European and Western cultures think about ecology as a kind of civilization wilderness dichotomy, and how instead in Indigenous knowledge frameworks often there isn't that dichotomy, and unless you engage with the moral underpinnings of how these two knowledge systems work, they won't come together effectively. And this also helps with thinking about how Western and scientific knowledge can be used alongside Indigenous knowledge. One of the key criticisms or feedback that was provided to the federal government in the parliamentary committee reports provided by Indigenous communities was that Canadian governments or assessments need to place Indigenous knowledge on equal footing with scientific knowledge. And scholars have discussed how this is on its face a difficult and almost impossible goal, as whenever you bring two knowledge systems together, one is going to have to assimilate aspects of the other, and if both are going to be on the same footing, each will have to assimilate aspects of the other. And so if we want to bring Indigenous knowledge into environmental assessment effectively, arguably science needs to give way as well as Indigenous knowledge into a system that shares understanding of both frames of knowledge. And Burrows kind of supports the idea that we then need to think about the philosophical underpinnings of both systems and educate decision makers on how to think about their moral philosophies underlying how they think about these forms of knowledge. And so when I turn to the 5 projects that I looked at, the Goliath Gold Mine Project, Blackwater Gold Project, Cote Gold, Red Mountain, and Menango Gold Project, I thought about what forms of knowledge were being treated as traditional knowledge, what was the method that this knowledge was compiled with, how it actually got implemented in assessments, and how the 3 purposes that I identified earlier were served by that knowledge, whether it was furthering a new form of evidence, understanding of Indigenous perspectives, or furthering sustainable development. And generally what I observed is that it was only serving the first 2 purposes, and I'll go through an example in a moment, but generally what traditional Aboriginal traditional knowledge was treated as within these assessments was purely small facts that were extracted from what were called traditional knowledge and land use reports provided, funded by proponents and provided to the Environmental Assessment Agency, but generally used by proponents in their development of environmental impact statements. So this mirrors the criticism in the literature of extraction of of knowledge and then it being handled and used throughout the assessment process by people other than the community and being extracted from context. When I looked at how the knowledge was then applied in decision making, I found that it became increasingly opaque as you moved through the environmental assessment process. So when I looked at draft reports for the environmental impact statement and the way that the environmental assessment process under the Canadian Environmental Assessment Act of 2012 works is it would begin with the project getting designated, and then proponents will prepare an environmental impact statement, and then that gets feedback from Indigenous communities and relevant ministries, generally from both federal and provincial governments, because there's a collaborative approach under the legislation to only have one environmental assessment at one level of government. And then the assessing environmental agency will prepare a final decision on whether the project has significant adverse environmental impacts, and then a minister will look at that and decide whether the project goes forward. As it moves through that process, the reasons provided in the documents of decision makers and the proponent move further and further away from describing how they're using traditional knowledge, and it becomes very opaque where that knowledge is being considered. But when I looked at the environmental assessment decisions, all of them cited that they used traditional knowledge as a basis for their decision and cited section 19.3, which is the provision of the Canadian Environmental Assessment Act that provides the option of considering Indigenous knowledge. And so a key problem that I found with this was that the instances where Indigenous knowledge was the basis for a proponent's assertion of how a project would impact the environment, and the situations where an Indigenous community had provided feedback based on, in the same way that a government provides feedback on the project's environmental impacts, got conflated once you got to the environmental assessment and minister's decision level of evaluating a project. And the perspectives of a community as a community consulting on a project or providing criticism, evaluating the report as another government affected by a project were treated the same as Indigenous knowledge provided as evidence for how this project would affect the environment. And there was a merging of consultation with use of Indigenous knowledge as a form of information, even in assessment, which is problematic in that traditional knowledge is not the same thing as political opinions or governance structure, governance of the environment between different nation-to-nation governments, nor is it what the Canadian government sets out as the goal of using traditional knowledge and considering traditional knowledge in its policy guidelines. And then when I looked at how knowledge was used alongside other forms of evidence, I was hoping to find how Indigenous knowledge would be used alongside science and when it complemented the science and was used to support the science. And there were instances where I found that it was used in support of science. I did not find any instances where it was used and accepted as contradicting science and then adopted instead. But most interestingly, I found that it was almost only ever used in discussing the factors under the environmental assessment relating to impacts on Indigenous people. So under Section 5 of the Canadian Environmental Assessment Act, the factors that assessment is conducted under are listed, and there's 3 that affect Indigenous communities. And it was almost exclusively when speaking to how a project would impact traditional habitat use or traditional hunting or traditional resource use that traditional knowledge was integrated, not in consideration of, say, how the project would impact fishing generally under other factors. So this knowledge was used in a quite restricted way, not even being used as evidence to support factors that are generally assessed under scientific frameworks. And so I just have a quick example of one piece of traditional knowledge and how that knowledge moved through one project's assessment process. So this comes from the Blackwater Gold Project. So this quote here is from the environmental impact statement compiled by the proponent of that project, the company trying to develop the mine. And they, under their assessment of habitat or of impact on traditional land use, they say that traditional berries were considered crucial in trade and potlatch ceremonies. Berries picked and planted, gathered still occur today. So that's the knowledge that they're extracting from a traditional knowledge land use study that was provided to them by communities. And then they discuss how they got that knowledge. So we see the methodology used, and then they discuss how interviews were conducted. And then if we move into how that same factor is discussed in the actual environmental assessment done by the assessment body, we see how, when the proponents were providing their assessment of the overall effects that the project would have on food security, that traditional knowledge got lost in the mix. And the assessment agency in this one instance highlights that as a problem and doesn't find against the proponent on this factor, but does criticize it because the proponent there used a study to assess the effect that their project would have on a community's food security by using moose harvesting as a proxy and ignoring other food sources. And so the traditional knowledge that was provided to the proponent was not integrated into their assessment of what the adverse effects of that project would be overall. And this is actually one of the, I found 2 instances where the assessment agency noted this and called on proponents to use Indigenous knowledge better, though in neither case did it result in the assessment agency finding differently from what the proponent suggested, which was that there wasn't significant adverse effect from the project. And so I'll just take one moment now to discuss where this leaves us. The Impact Assessment Act makes a few small changes that I think in some ways are quite significant. Firstly, it changes the purpose of assessment to include sustainability, opening up the possibility of use of Indigenous knowledge furthering a different purpose than merely enhancing evidence or understanding of Indigenous perspectives, and instead moving towards a model of use of Indigenous knowledge that furthers sustainable development. We see the purpose there. It also becomes mandatory for the assessment agency to consider Indigenous knowledge and for the agency to discuss in its reasons how it used Indigenous knowledge. And I think that this is crucial and possibly the most important part, especially in light of Vavilov and its discussion of how statutory frameworks require decision makers, if they're to have reasonable decisions, to discuss and clarify their reasoning in light of the statutory frameworks that they make decisions under. I think this means that we'll be able to scrutinize much more closely how decision makers are actually thinking about Indigenous knowledge and possibly better identify where the moral and legal underpinnings and understandings of Indigenous knowledge versus Western forms of knowledge, and whether these are being done fairly by decision makers. One of the primary concerns that I had reading through environmental assessments was how opaque decision makers' understanding of Indigenous knowledge was, and how it was often cited, the word traditional knowledge was used without any discussion of that knowledge and how it was being considered by decision makers. And I hope, and I think that it could be that this requirement for reasons changes that slightly. But I do think that the Impact Assessment Act falls quite short in other respects. A guidance document could help with requiring decision makers to use Indigenous knowledge, not just in respect to factors of assessment relating to Indigenous traditional land use. And I think that could be productive. But the impact assessment as it stands does not provide for changes in power over the knowledge. Doesn't require that knowledge isn't used in a piecemeal way, as I saw it was used in my assessment of the mining projects. And it doesn't call for any change in the perspective of decision makers or better understanding of how to think about this knowledge in an integrated way with other science. So I'll then open things up for questions.
Hi, Eileen. Two questions occurred to me. Is Indigenous knowledge important for this purpose primarily because it's Indigenous or primarily because it's knowledge? And why?
I think I would say because it's knowledge, not because it's Indigenous. And I think that that comes to the point, some of the criticisms about Indigenous knowledge just being another form of consultation. So if Indigenous knowledge is to add something to assessment that isn't provided by the duty to consult, then it needs to be treated as another form of understanding how projects in the environment work together, and how projects can impact the environment. And I think that's an instance where it provides something different from the duty to consult. Otherwise, we should be thinking about enhancing the duty to consult and the legal frameworks for including Indigenous perspectives and knowledge in that framework. The impact assessment and the requirement for inclusion of Indigenous knowledge is separate from the duty to consult framework and creates a statutory obligation to consider this knowledge. And I think that for that reason, it should be thought about in terms of the knowledge that it brings rather than the fact that it's Indigenous.
Okay, quick second question. One of the things I think I know about Indigenous knowledge is that it's not necessarily in the public domain. It is, in a sense, perhaps proprietary and not everyone's business. Sometimes Indigenous communities are concerned to keep close some of their traditional knowledge because you have to earn the right to have it shared with you. Assuming for the moment that I'm right about that, how does that factor into this discussion?
That's absolutely right. I think that one point I'll make is, I didn't discuss this, but the impact assessment does create privacy frameworks and protections for Indigenous knowledge that was absent under the Canadian Environmental Assessment Act. And that was the result of feedback provided by communities, basically because it was such a barrier to Indigenous knowledge being shared for environmental assessments. But I also think that this comes to a section of my paper that I haven't thought through quite yet. But at the end of my paper, I want to discuss whether Indigenous knowledge belongs in environmental assessment and kind of critique the idea of it being included whatsoever. And the primary reason for that is that if we're not able to shift moral thinking of decision makers, if we're not able to give communities power over how their knowledge is being used throughout a process, it begins to undermine the purposes that I talked about at the beginning. Communities become disheartened with sharing or engaging with decision makers when the knowledge that they provide and that they've spent so much time compiling isn't reflected in assessments in the end, or isn't portrayed properly, or isn't handled fairly. And so the question becomes whether a assessment system that is so fundamentally structured in terms of Canadian Western legal systems ever can properly bring in Indigenous knowledge. And I think part of that is the confidentiality aspect and who should be sharing in that knowledge. And another part of it is the ability of that system to comprehend it and use it properly if it's using a very Western form of governance and assessment rather than the legal systems where that knowledge is normally used.
Thank you.
Eileen, can I ask a couple questions? Kind of two related sets of questions. One of it, so it's really interesting. So it's great that and I really like the fact that you went and looked at individual environmental assessment reports is something that a lot of people do is kind of doing the groundwork. I want to ask you a question about that though, first, which is you picked 5 gold mines. Can you talk a little bit about that and its relation to what you're taking away from how the Canadian Environmental Assessment Act works? So is there concern that gold mines give you a particular slice and a particular way of using information that others might, other types of environmental assessments might not? And secondly, and this relates to my other question, which I'll come to after, but secondly, what's the time period that you took these case studies from? Because I could imagine if they were all from sort of the Harper years, that the composition of the panels might be different, and then it might make us think about different ways about structuring how this system works.
So I do think that it does give me a particular slice of how knowledge might be used. So the framing of the 5 cases I chose were that they were mining projects that were completed, or the assessments were completed in 2019. So they were the most recent of assessments that I could come upon, but that didn't mean that they weren't assessed or touched on by the Harper years and the Trudeau years. So the assessments began usually between 2012 and 2014, and then so that was when the proponents were, beginning their impact statement development and then providing the impact statement drafts, and then the end of the process would be 2019, like March, February 2019 for these reports. So the assessment decisions were being made under the Trudeau government, but the earlier processes would have been in Harper years. But that I actually don't think necessarily made too much of a difference, because the policy guidance, or at least not in an overt way that is available publicly, the policy guidance documents for how to use traditional knowledge were updated in 2015 when the Trudeau government came in and almost word for word copied the guidance documents that were in place before then. So I actually don't know how much change occurred before the Impact Assessment Act has made these changes. And I chose that time period of 2019 to try and get a sense of where we're at before the changes occur under the Impact Assessment Act, to get a snapshot. And I chose one type of project because I wanted to be able to see how the particular decision makers and the particular proponents interacted, and the different communities and the types of knowledge that were provided would play out differently in different projects, when the projects themselves remained quite similar and the impacts on communities remained similar, except for the communities changed. And I found that quite helpful because it meant that I got to see how a proponent that was, creating a tailings pond and a powerhouse and open pit mine in BC versus Ontario, how that and their discussions of those impacts, even though the impacts were generally quite similar on the environment, it depended on whether there was like a water body nearby, how those things not changing, but the Indigenous knowledge provided changing, or the assessor changing, would make a difference. And so I did find that there was like variability in how the assessment agency looked at that knowledge, even when the knowledge didn't change that much, or the proponent's project didn't change that much. But yeah, definitely a snapshot of one particular type of project. And I haven't actually thought about the composition of panels, but I think that that's an interesting thought to bring into my discussion of how moral perspectives on knowledge and how to think about knowledge, maybe that could be a space where that could be improved upon, is composition of assessment panels.
Yeah, it is a change that the Trudeau government brought in across a range of different types of regulators, including the National Energy Board, which is now the Canadian Energy Regulator. They decided they try and change or put requirements on who can actually sit on those panels. And the question would be whether that would make a difference to how you felt about incorporating, especially your last, you say, well, now I want to take kind of indigenous knowledge completely out of the process, and whether that would make a difference to you, that kind of, if we can alter the composition of those panels. It's related to the other question I had, which was around who should be making this decision. So under SIA 2012, we had this kind of decision-making process where a panel decided whether there were significant adverse environmental effects, and then it went to cabinet on some projects to figure out whether those adverse effects were justified. The new system has a slightly even greater separation in some respects between science and the kind of ultimate decision, with cabinet making now making a final decision around whether the project is in the public interest, and it has to consider certain factors in making that call. Do you think it'd be useful to have cabinet also have to specifically consider how indigenous knowledge enters into their decision making? I mean, there's a reason giving component there, but I mean, so there's two ways in which you can go. You can kind of put more emphasis on cabinet making this call, or you can put more decision making responsibility on these individual panels down below. Do you have kind of thoughts around how that plays out at all?
I mean, I think that the cabinet decision layer, providing reasons or thinking about indigenous knowledge on top of the assessment body and its reasons provided to the cabinet. I don't know how helpful that would be. I mean, one of the biggest criticisms I have with, bringing in indigenous knowledge as a factor in assessment separate from the duty to consult is we already have this notion of, the Crown is in charge of the duty to consult on top of like the assessment agency can engage in what counts as the duty to consult, and then the Crown still has the responsibility to go back and make sure that the duty to consult has been fulfilled. If we then have again another layer of, well, cabinet needs to make sure that indigenous knowledge was brought in properly, I think I don't think that would make for more robust decision making that is based on that knowledge. I think it would meld things with the duty to consult obligations in a way that I think wouldn't be helpful. I think that a system, if we're going to bring indigenous knowledge into these assessments, which I do think has value if we have this framework at the moment, if we have a system where, the Canadian government is governing what projects end up on, treaty or title land, I mean, that whether that should be the case is a separate issue, but I do think there's value in these knowledge systems being part of the assessment. I think that going down to who is making the recommendations to cabinet and their understanding of this knowledge, I think could be a better way of addressing how it's getting integrated.
Great, thanks.
I'm mindful of the time, but
yeah.
I do have a quick question. And I couldn't help but think while I was listening to your presentation, during which I learned quite a lot. Thank you. Is there a problem here around translation? And that is, the idea is, I gather that Indigenous people know stuff about the world that we could describe as facts, and that those facts should somehow inform environmental policy. But it just seems like that translation part around the policy thing is pretty widely open to interpretation. And I'm wondering if has any thought been given to not looking at traditional knowledge, but looking at Indigenous law. So, for example, we know, as a matter of fact, that if you run raw sewage straight into a river, it despoils the river. But knowing that isn't the important thing here, I think. Isn't knowing that we have a rule now that says don't put sewage into water. And so instead of focusing on the knowledge, has any thought been given to focusing just on the system of laws that knowledge informs as a way of regulating environmental behavior?
Yeah, I think that's really important. So I found that came up most in John Burroughs writing about this issue. And I think that it comes into this idea of whether using Indigenous knowledge or Indigenous knowledge encapsulating Indigenous governance towards sustainable development. And I think that when we look at the international community talking about assessment bringing in Indigenous traditions and Indigenous knowledge. What they really are talking about, even though they don't articulate it that way, is Indigenous governance and law coming into assessments. And it's not really about the facts. Yes, there is, you know, communities have knowledge and understanding that maybe a scientist coming in now won't pick up on, or will have, you know, a different, less integrated or a different way of articulating those facts. But Burroughs' main argument is that if assessments are going to serve in sustainable development, you know, thinking about the land lasting for future generations rather than present use, it's really Indigenous law. And when we look to Indigenous storytelling, or we look to knowledge that's passed on through generations, or understanding of the land, that's really law. It's not knowledge, and we can't bring Indigenous knowledge into these systems without changing governance. And I think that is ultimately true, and basically the critique that I want to come to at the end about the shortcomings of the Impact Assessment Act.
Thank you.
Everyone's able to see that, right? Okay, good. Okay, so by way of introduction, I just wanted to tell everybody that unlike my fellow presenters, I'm satisfying the research requirement for the certificate via a directed research project, so not a SURA. My research has been directed by Dr. Cindy Blackstock, who is the Executive Director of the First Nations Child and Family Caring Society, or the Caring Society for short, and it's been supervised by Professor Sanderson. So my title for my research has changed a bit from what it was when it was initially announced. It was talking about implementation strategies, but as I got into my research, I found that jurisdiction and the limits put on it by Bill C-92 were so limiting that I preferred to talk about that because implementation strategies are very frustrated by the internal limits. So my research is called Sabotaging Self-Determination. It's about BL C-92 and recognizing Indigenous jurisdiction over child and family services. So my presentation will be in 3 parts. So first, I'm going to provide a general overview of Bill C-92 very briefly. Then I'll offer a theory on why I believe the federal government chose to legislate in Indigenous child welfare and why now. Second, I'll speak about the best interests of the child under Bill C-92, comparing Indigenous communities' self-determined vision on what healthy children and families looks like to what Bill C-92 articulates in its principles and national standards. And third, I'll talk about funding and paramountcy. And I'll explain more, but I argue that these are 2 features of Bill C-92 that further hamstring self-determination. So very quickly, I just wanted to talk about my thesis of my research in 3 parts. They line up with the 3 parts of the presentation as I've outlined. So first, I argue that Bill C-92 purports to affirm Indigenous people's right to self-determination, which includes jurisdiction in relation to child and family services. However, I suggest that Bill C-92 is properly understood as a move by Canada to offload responsibility for Indigenous child and family services. And second, that it's a direct response to the Caring Society litigation, including the 9 non-compliance orders that have been issued against Canada since the original decision, which was 2016 CHRT2. Second, I argue that Indigenous communities know what is best for Indigenous children, and Bill C-92 is a far cry from that self-determined vision of what healthy children and families looks like. Third, I argue that Indigenous governing bodies exercise of self-determination and power to implement its jurisdiction over child and family services under this bill are sabotaged by a lack of funding and the doctrine of federal and provincial paramountcy. So just very briefly, I want to talk about what Bill C-92 is for people who don't know. So the stated purpose of Bill C-92, its full name is An Act Respecting First Nations, Inuit, and Métis Children, Youth, and Families. But that's a mouthy title, so people tend to just call it Bill C-92. The purpose is to affirm the rights and jurisdiction of Indigenous peoples in relation to child and family services as part of an inherent and Aboriginal right to self-governance. So Bill C-92 does 2 things. First, it establishes a small number of principles in Section 9 and national standards, Sections 10 to 17, to help guide the provision of Indigenous child and family services. So these services, these standards are designed to fill gaps in provincial and territorial child welfare laws that apply to Indigenous children. So these came into force January 1st of this year. And the second thing that this act does is enables Indigenous groups and communities to transition towards exercising partial or full jurisdiction over child and family services. So I'll go into more detail about the federal principles and standards in the second part of my presentation, but there's a couple key aspects of jurisdiction that I think I should address now. So in the preamble, Canada affirms the right to self-determination of Indigenous peoples, which includes the inherent right of self-government, and then under that falls jurisdiction in relation to child and family services. Section 18 makes this binding. Section 18 says that the inherent rights of First Nations, Inuit, and Métis affirmed in Section 35 of the Constitution Act of 1982 include jurisdiction in relation to child and family services, including legislative authority in relation to those services and authority to administer and enforce laws made under that legislative authority. So what does this all look like in practice? So it's up to Indigenous governments to decide whether to use Bill C-92, when, and what their laws will say. If an Indigenous government wishes to use Bill C-92, two steps are required. It must give notice to the provincial and federal governments that it intends to exercise its jurisdiction. And second, it must make, quote, reasonable efforts to reach a coordination agreement with the aforementioned government. The coordination agreement really is just an agreement talking about exercise of authority. And most importantly, what everyone seems to be focusing on is that coordination agreements is how the governments and the Indigenous government would figure out fiscal arrangements. So once this coordination agreement is made, or after 1 year, as long as there have been reasonable efforts made, then the Indigenous law will have the same force as a federal law. This, I note, is subject to a number of very important caveats, which I'll speak about at close to the end of my presentation. So the question, why child welfare and why now, has puzzled a lot of people. The federal government has no experience making child welfare laws before C-92, and it shows. Many First Nations have objected to the content of the law, which is very confusing and vague. And the federal government claims every time it's reported about Bill C-92 that it was co-developed. But in reality, it was a rushed consultation process. Only national Indigenous organizations were consulted, and consent was not sought or obtained. The Chiefs of Ontario, in fact, reported to the Senate Standing Committee saying that Bill C-92 was not co-developed in any legitimate sense of the word, and described the drafting stage as exclusive, rushed, and secretive. So here I have an infographic that kind of takes you through a timeline of the creation of Bill C-92. So in January 2019, there was a national emergency meeting held by then Minister Jane Philpott. Then in June, engagement sessions were held, which is what I just spoke of, where they only consulted a handful of national representatives. Then there's the initial drafting of the bill from December to February, which was very rushed and secretive. And before you knew it, the bill was introduced for first reading in February of 2019. So why child welfare? Why now? Well, I propose that Canada's eagerness to offload jurisdiction over Indigenous child welfare has everything to do with the Caring Society decision and the 9 subsequent non-compliance orders that have been issued by Canada against the CHRT. So very briefly, I'm sure everybody knows about the Caring Society decision, but if you don't, brief background is that in 2007, the AFN and the Caring Society filed a human rights complaint against Canada alleging its funding for First Nation child welfare and failure to properly implement Jordan's principle was discriminatory. In 2016, the CHRT issued its decision, which I cited there, substantiating this complaint. So to date, Canada has yet to comply with this order, and as such, 9 subsequent non-compliance orders have been issued against Canada. So I place particular emphasis on the 6th non-compliance order, which was issued February 1, 2018. This is interesting to me because it was issued less than a week after the emergency meeting was held, just a few months before those engagement sessions were held. And it's the most severe admonishment of Canada regarding its funding commitments. So as I just note briefly here, it admonished Canada for continually relying on its incremental approach to equality. It found that they'd been thinking about financial considerations and not ever thinking about the best interests of children, that it had wrongfully treated tribunals' legally binding orders as nothing more than recommendations, and that Canada's response suggests that it did not grasp or did not care about the seriousness and emergency of the issue. And this order, the sixth non-compliance order, is where the tribunal ordered Canada to cost out the extent of the underfunding of First Nations child and family services, identify actual need, and fully fund the actual costs of prevention and least disruptive measures. So I suggest that this order, due to its timing and how severe the admonishment was, as well as the particular content of the order, as it was specifically about funding, was a contributing factor to the federal government deciding and very quickly getting federal legislation out and through Parliament. So the next section of my paper talks about the best interests of the child. I just want to give some brief background to touchstones of hope. So the Indigenous child welfare crisis prompted the creation of the Touchstone of Hope principles in 2005. So these principles came out of 200 leaders coming together to attend a conference on Indigenous child welfare. It was held in Niagara Falls. These principles are community driven and are said to reflect the best interests of Indigenous children and families in child welfare policies. There are 5 principles, which I don't note on the slide, but here they are. They're culture and language, holistic approach, structural interventions, self-determination, and non-discrimination. So the Northern BC Touchstones of Hope movement was the first time Canada chose to engage in broad-based child welfare reform, guided by these principles. It was a collaboration of 6 First Nations and their family service agencies, as well as the provincial ministry and the Caring Society. They facilitated workshops with leaders and communities for over 3 years and captured the relevant feedback and kind of tested the waters with the community as to what they thought were the best interests of their children during small group discussions held during the process. So what I've put onto the slide here are the, in 2012, the results from the community sessions were published. And these are some of the more salient points that I drew out of the report as it pertains to the best interests of the child. So as you'll see from the slides, the community session participants really focused on how self-determination could be boiled down to the principle that Indigenous communities know what is best for Indigenous children. And another finding was that every community believed in the importance of providing culturally grounded services and programming rooted within their own worldview and way of life. So for these communities, self-determination was equated to a community's ability to develop their own child welfare cultural programming that meets specific community needs and that they're able to deliver in their own language and culture. And dreams for the future, dreams for their children and their families and their communities included wanting children to feel valued, loved, wanted, secure, and cherished. Participants indicated that people should be ensuring children's safety and be fully present in their lives, and that children should have healthy guardians, know their community's history, and have opportunities to reach their full potential. Now, the principal theme coming out of the Northern BC Touchstones project, as I've said, was that Indigenous communities know what's best for Indigenous children. The next part of my presentation, I'll talk about how Bill C-92 is a far cry from this self-determined vision of healthy children and families held by Indigenous communities. I know the Northern BC Touchstones project only involves 6 First Nations in BC, so they of course do not speak for the entire Indigenous population of Canada. But the Touchstones project is one of the only projects of its kind, and I think gives a very interesting and important view of what best interest of the child means from the Indigenous perspective. So now I'll go through and compare a little bit. So I kind of looked at Bill C-92 and then looked at the Touchstones research, and I asked, okay, well, what is the goal of Indigenous child welfare legislation according to these two regimes? According to Bill C-92, the goal is to eliminate the overrepresentation of Indigenous children in child and family services. For touchstones, quite differently, the goal is to restore the holistic health and well-being of First Nations children and families by strengthening protective factors of culture, language, tradition, customs to each First Nation, and thereby eliminate the overrepresentation of Indigenous children. I think there we're able to see that Bill C-92 and the federal government focuses so heavily on the reduction of overrepresentation because that's what's in their interest, that's what they've been getting in trouble for in the courts and tribunals, where the touchstones view kind of looks at Bill C-92 and sees it as restricting a more holistic First Nation and Indigenous approach that's situated within the context of community. So next ask, well, what are child and family services? And this has been a big point of contention since Bill C-92 was released. Bill C-92 just says it's prevention services, early intervention, and child protection. Touchstones, on the other hand, is adamant that legislation must require the provision of government support past the age of majority. In addition to post-majority care, there's also concerns that guardianship and adoption are not discussed in Bill C-92, but they are in fact critical elements to Indigenous nations' self-determined vision of what a healthy family and child and family system looks like. So next question I ask is, what universal principles should apply to the delivery of services to Indigenous children and families? So Section 9 enumerates the principles of Bill C-92, of which there are 3. The first is best interest of the child, which ultimately just says that every decision must be made with reference to the best interest of the child. So that's an agreeable provision and one that's in every Child and Welfare Act in existence. The next is cultural continuity, which is largely satisfactory, although there have been complaints that it's quite vague. It's missing a lot of positive obligations to ensure the health of culture, as it's been the target of assimilation practices and objectives. And the big flaw that people have pointed out under cultural continuity is that it does not make reference to the sacred relationship that Indigenous children have with the land and territories of their ancestors. And third, substantive equality. Part E of this, so 9 sub 3 sub E, says, in order to promote substantive equality between Indigenous children and other children, a jurisdictional dispute must not result in a gap in the child and family services that are provided in relation to Indigenous children. So you're probably thinking, oh, that sounds like Jordan's principle, and it does. This was the federal government's attempt to include Jordan's principle into substantive equality. But the problem is that this section really narrows the CHRT and the federal court rulings on Jordan's principle. The federal court made clear that jurisdictional disputes are not required to trigger Jordan's principle, and the CHRT adopted this position and added that Jordan's principle is not limited to gaps in service. So right there you see the federal government narrowing these really important decisions for First Nations children and their families by expressly disregarding what the CHRT said and what the federal court said. So next part is, what are the best interests of the children? And this is kind of the crux of this part of the presentation. Section 10 states that the best interests of the child must be the paramount consideration in the making of decisions or the taking of actions in the context of child and family services. So the priority of the best interests of the child would not be a problem if not for the way that this principle has historically been interpreted and applied to cases involving Indigenous children. So Canadian courts have rarely determined it to be in the best interest of the child for an Indigenous child to return to their Indigenous family or community once they've been placed in a non-Indigenous home for any length of time. Similarly, there's a common judicial misinterpretation that a child's need for community and culture be balanced against their best interests. Now, what this means is that this suggests that without strong mandatory language to address this judicial bias and to clearly overtake binding precedent, this biased interpretation of the best interest of the child will almost certainly continue to prevail over other factors that recognize the unique situation of Indigenous children. And going back to the previous slide, I noted at the bottom that the cultural continuity and substantive equality principles are diminished by Section 10, and they are because Section 10 states that best interest of the child is the paramount consideration. So if this is interpreted in a biased way, This bias interpretation that balances the child's needs and community against their best interests will in fact also override their right to cultural continuity and to substantive equality. Now I wanted to kind of put up on this slide how best interests of the child are assessed. So the previous slide was kind of talking more about their priority, but this is how they're assessed. So section 10.3 of Bill C-92 outlines the factors to be considered in determining the best interests of the child. We see culture and linguistic, religion and spiritual upbringing. I won't go through them all, but I think it's an interesting comparison that very little has to do with the child and their specific Indigenous upbringing and their culture and the values that are important to Indigenous children by virtue of being Indigenous. With the bottom two actually talking about family violence and civil and criminal proceedings against caregivers. So I compare this in the next slide to the draft First Nations Family and Caring Act. This act was drafted by Dr. Blackstock and a number of other academics before Bill C-92. I won't go into too much detail right now into how it was developed, but it was developed with direct relation to the touchstones of hope and the principles brought out of that. And I think it's just a very interesting comparison on how these best interests of an Indigenous child in this draft act, which has been submitted to the federal government to be enacted under Bill C-92, and it was rejected. The federal government saying that each individual nation is going to be required to produce their own. There can't be one child caring act for all First Nations children, which is problematic and very frustrating. But here we see that Indigenous children have the right to safe and nurturing environment, to grow up to their full potential, that there is a sacred connection with family, community, and nation. They have a right to kinship and extended care, to live their culture and speak their language, to have access to traditional lands and resources, to have their wishes considered and taken into account. And number 9, especially states right there in the best interest of the children that First Nations are best positioned to make decisions that affect their children, youth, families, and communities. So I think that's the expression of self-determination that is not present in Bill C-92, and that a lot of nations had very severe issues with that. So the last part of my presentation kind of answers a question that you might all be asking. So you might be thinking, what does it matter if Bill C-92's vision of healthy children and families is deficient? Because under Bill C-92, can't Indigenous governing bodies just draft their own legislation that would override this deficient federal law? That would be great, but unfortunately, due to 2 things in the bill, that being total and complete lack of funding, and the second being the paramountcy provisions that are baked into C-92 that are triggered in the event of a conflict of law. Those 2 things, funding and paramountcy, mean that the dangers in Bill C-92 are even more present and unavoidable for most nations. So I'll talk about funding first. What funding guarantees are contained in Bill C-92? The short answer is none. Funding is, of course, essential to the realization of Indigenous jurisdiction, but there is nothing in Bill C-92 that binds the federal government to provide any funding. Bill C-92 actually refers just once to funding. This reference is in the non-binding preamble and acknowledges only, quote, the ongoing call for funding for child and family services that is predictable, stable, sustainable, needs-based, and consistent with the principles of substantive equality in order to secure long-term positive outcomes. This I find very frustrating. Of course, this is non-binding, but they filled it with lots of pretty language, a lot of hope for positive obligations, but of course there are none that flow from the preamble. Otherwise, C-92 only mentions funding under sections 20 as a matter to be negotiated under collaboration agreements or coordination agreements, which I spoke about earlier. This legislation also does not address funding for capacity building. So for the development of Indigenous laws and for the negotiation of these coordination agreements, which is, you can imagine, is an extremely expensive process. For actually drafting the legislation, that's an incredible number of lawyers that need to be hired and consulted, and a lot of community work that needs to be done. And then negotiation, you're asking Indigenous governments to pay out of pocket to engage in tripartite negotiations with the feds, the province, and then the Indigenous government, those three parties at the table to negotiate funding for their children. That I can imagine, it's a very problematic ask from nations, especially if there's no funding on the table. Just briefly, I wanted to say that sections 14 and 15 are going to be most profoundly impacted by these funding agreements and the lack of funding that's extended already under Bill C-92 as the default. So section 14 requires that priority be given to preventative care. 14.2 gives primacy to the provision of prenatal services. And section 15 requires that no child be apprehended solely on the basis of his or her socioeconomic conditions. So to the first part for 14.1, priority has never been the issue. The priority to preventative care is something that exists in almost every child and family or every piece of child welfare legislation across the country. The issue has always been that it's been unavailable to Indigenous communities because of lack of funding. 14.2, also it's going to be affected because if there's no funding, how are you supposed to be able to provide prenatal services? Especially when you consider that there's no positive duty on the federal government to ensure adequate funding for child and maternal health or for infant development. And section 3 appears to acknowledge, or sorry, section 15 appears to acknowledge that the structural drivers of child maltreatment, but without imposing any positive obligation on Canada to redress the inequities that deepen those drivers. So poverty, poor housing, addiction related to multi-generational trauma, domestic violence. So really these provisions, I don't think will have any force or effect given that there's no funding at all. So in terms of how do we solve the funding problem, in my paper, I argue that Canada must recognize its legal obligation to ensure adequate and stable funding to do more than what the preamble states as acknowledging the ongoing call for legislation, for funding rather. Second, they must fund the full costs associated with child and family services contemplated by Indigenous laws. So these include core and operational costs, and also capital costs in terms of infrastructure, and must adjust for inflation. And third, I argue that the federal government must provide adequate funding for the development of Indigenous laws and supporting institutions and services that are required in order to enable Indigenous governments to implement their own jurisdiction over child and family services. And the last thing I want to talk about is paramountcy. So section 18, as you'll remember from the very beginning, recognizes the inherent right of self-government recognized and affirmed by section 35 of the Constitution Act. Basically says that Indigenous governments have authority and jurisdiction to legislate in the area of child and family services and to enforce laws made under that legislative authority. Section 18 sounds great if you read it just quickly, but if you read it in kind of take into account other provisions in the Act, you'll see that it's really problematic because section 18 must be read together with sections 4, 19, 22, 23, and 32, which I have up on the slide, which all include provisions that could infringe on First Nations jurisdiction. So under section 4, basically says that First Nations laws can be challenged for non-compliance with the principles enumerated in section 9. That was best interest of the child, cultural continuity, and substantive equality. And as I flagged earlier, the best interest of the child is really problematic as it diminishes the other two principles. So that kind of biased way that courts have interpreted the best interest of Indigenous children can really come to head at section 4. Section 19 says that the Charter of Rights and Freedoms applies to First Nations jurisdictions. Section 22 says that Indigenous laws prevail over provincial and territorial laws, and they prevail over federal laws, which sounds great, but Indigenous authority is limited by stating that Indigenous paramountcy over federal laws does not include sections 10 to 15 of Bill C-92. So those are the sections dealing with the best interests of the children. Again, a huge problem. Section 23 is the section that most people take issue with and take issue the strongest with. So section 23 enables First Nation laws to be infringed if there's a determination that a provision in an Indigenous law is not in the best interest of the child. So in the event of a conflict of law, that provincial or federal law will prevail. So this legislation, Section 23, creates the possibility that interpretations of the best interests of the child by Canadian courts will lead to Indigenous lawmaking jurisdiction constantly being challenged and overturned. And lastly, Section 23, entitled Regulations, says that if affected Indigenous governing bodies were afforded a meaningful opportunity to collaborate in the policy development leading to the making of regulations, the Cabinet may make regulations providing for any matter relating to the application of this Act or respecting the provision of child and family services in relation to Indigenous children. So that's really long. What does it mean? It means that the Cabinet may use regulation-making power under Section 32 to limit First Nations jurisdiction. The requirement that First Nation governing bodies be afforded a meaningful opportunity to collaborate is vague. There's no definition as to what meaningful opportunity to collaborate means, nor is there any jurisprudence to guide such an interpretation. So what it means is that if Cabinet thinks that they've consulted Indigenous governing bodies enough in a meaningful way, the Cabinet can at any time step in and legislate in the area that Indigenous people supposedly have exclusive jurisdiction in. So those 5 sections kind of read together really do limit the jurisdiction that's afforded to Indigenous governing bodies and communities under Bill C-92. So taken together, funding and paramountcy really limit Indigenous governing bodies' ability to get out from under the very deficient Bill C-92 and legislate in a way that reflects how they feel their children and families and communities should be provided for, because there are not resources to do so. And second, even if they did do so, the provisions baked into Bill C-92 reflecting paramountcy in the event of conflict of laws really hamstring any nation's ability to exercise their self-determination in this area. And that is it for me. I just put my thesis up again, and that's the end.
Great, good job, Jessie, thank you. So we've gone a little longer than we had, but very well done. Give silent clap. We'll move to questions, and I thought maybe we would give Professor Dawood or Sarah Faraday an opportunity to ask questions, as we haven't had any questions from those 2 participants. And then, of course, we can go to the other professors.
This is Yasmin Dawood. I thought that was an excellent presentation and a really fascinating research project, Jessie. I really think it's terrific. I found it quite striking, actually, the difference between the bill as drafted and sort of was it the BC Northern? I can't remember the name of the recommended list of norms and ideals that the bill should work towards. So I guess I'm curious, why is there such a huge gap? Did you get a sense of why there's such a disjunction between the bill as drafted and sort of what the community members were suggesting should be in that kind of bill?
So I think a lot of it comes down to the fact that if you understand Bill C-92 is actually the federal government doing its best job to empower communities to do right by their children, then the fact that there is such a divide doesn't make any sense, because you think it would be their top priority to consult nations and determine exactly what the content of the best interests of an Indigenous child is. But if you think of Bill C-92 as a way of Canada offloading its responsibility and liability for overseeing the child and family welfare service system for Indigenous children, then I think it's much more reasonable to see the federal government doing a very hasty job and doing it in a way that limits what is going to have to be coming out of their wallet. Because if nations remain under Bill C-92, any promises made in that legislation have to be directly funded by the federal government. So I think they're very careful not to make promises that they're not willing to pay for. Those promises such as under the draft act, kind of the better list coming out of the touchstones include, no child should be removed from their home and their family due to poverty and other socioeconomic conditions that plague their family, which is great, but it's not something that Bill C-92 would have in it, because if a government thought, wow, Bill C-92 is great, why should I shell out all of this money to take over the system when the feds have done such a good job of listening to our concerns? The feds would be on the hook for paying that hefty price tag. So yeah, I think it comes down to how you understand Bill C-92 and the motivations behind it, and also realizing that the feds are on the hook financially for any promises they make in Bill C-92.
So yeah, I thought that was a great presentation too, Jessie. Thank you. I've done a little family law in low income communities. That was my sort of pro bono little side gig when I lived in New York State. And it's always really the most difficult questions in family law circle around disentangling the socioeconomic factors from the best interest of the child analysis. There's so much overlap, or if you're sloppy in your thinking, you think, well, that's a nicer house. There's a stay-at-home parent in that house. There's an emotional connection already existing here. It's just very, very, there's so much opacity around doing the best interest of the child analysis under the best of circumstances. And it gets more and more difficult as socioeconomic resources are deflated. And I do feel like that's the hardest question to answer. And the effort has to be to develop a really nuanced analysis in the context of indigenous communities. And that work, I'm so interested in seeing that work get developed and that work get done. Obviously, the funding issues are paramount to that, but I do feel like when I read like every Indigenous child deserves this, every Indigenous child deserves that, you can take the word Indigenous out of those lists for the most part. It does get more interesting when you start talking about First Nations communities have the right to do X, First Nations communities have the right to do Y. But I just wonder, is there work getting done on what I think of as the really hardest question, which is providing guidance around doing this in this very specific context?
Yeah, so it's definitely a big issue in how to turn the very individualized and kind of right here, right now assessment of what is in the best interest of the child, which of course you need to take into effect, what is this child's house like? Do they have their own bedroom? Do they have access to food and clean water? And, is there violence in the home? So I think what the Draft Act, kind of the better list of the best interests of the child principles, what it kind of demonstrates is the need for there to be a holistic approach where you cannot provide for the child in the best way unless you're providing for the family, unless you're providing for the community. So I think what a lot of the work right now that's going on kind of on the ground are communities taking upon themselves to find funding sources to provide like addictions treatment for parents and to provide capacity building opportunities for communities to learn how to kind of holistically benefit a family. Because as you've said, the best interests of the child have been applied on such an individual basis and such a like checkbox basis. What everyone's trying to do now is really fight against that and take a community perspective and a family perspective, and instead of a checklist, to look at it in a much more holistic way. But you're right, like those are the fundamental changes that need to happen. There needs to be money put towards preventative services and providing money to communities so they can create the best situations for their families and children to thrive. And I think that'll go a lot of the way in kind of providing for that holistic wellness of the community. But as I said, I think the biggest flaw of the bill is that it makes a lot of promises, but doesn't provide any funding for that holistic, dream to actually be attained. So communities, unfortunately, have had to pick up the slack, pay out of pocket, be resourceful, and just try and figure it out on their own.
Thank you.
Jessie, can I ask you about that piece? Yeah, so no, really interesting. I don't know anything about this area, but so if you don't get the funding piece, what does this bill look like to you? So I completely take your point that the best world would be we get funding for these communities, we get funding for the transition. So both kind of the substantive stuff and the kind of procedural legal part. What does it look like in a world where we have governments which aren't going to be willing or don't seem to be willing to give this money? Like, is there how does that change, or does that change your view? My kind of take when you first were describing this is that the federal government's trying to do this, recognizing that these collaboration agreements are saying, well, some communities are going to have funding, some communities have resources to do this, and we're going to work with those communities to help first, and then kind of broaden it out. But how does this look if you don't get any funding? Does that change your kind of view of what the bill looks like or should look like?
Yeah, so I think in practice, communities that aren't receiving any funding, to them, obviously the paramountcy side doesn't matter very much, because what they're left with in the event that they don't receive any funding is inability to legislate in this area. So they're left with Bill C-92, the principles and the national standards as enumerated. The entire jurisdiction element really falls away for most nations because that's something they can't afford to enable. So what they're left with is Bill C-92, which, as I kind of briefly went over, is incredibly deficient. For most reason, I think the biggest reason being how it interprets the best interest of the child, and how it does not do very much to kind of eliminate how judges and courts have interpreted best interest of the child in a way that really harms Indigenous children and communities. So I think, in communities that don't receive funding and are not financially able to exercise jurisdiction, the whole bill gets cut in half, and really all they're focusing on is Bill C-92 and all of its deficiencies. If a nation does not receive funding but has its own source revenue where it thinks that it can, make this happen on its own, there's still an issue. So Cowessess First Nation in Saskatchewan is the first and only nation to actually implement its own legislation under C-92. So they've gone ahead and done that. But the issue that they're running up against is the fact that they don't have, while they had money to draft the legislation and to coordinate with the feds, they don't have the money, either of what they have or what the feds have promised, to actually enact any of their own child and family services. So I think for communities that can afford to go through this process and exercise jurisdiction, you kind of run up against the issue of, okay, so we have jurisdiction now and we have our laws, but we cannot afford to offer them, or they can only afford to offer them in a really poor way, which opens up Indigenous communities to a significant amount of liability. So that's been a big concern of nations who say, look, we want to provide for our children, we want to put legislation in place, we want to coordinate with the federal government, but at the end of the day, the federal government, we just know that they're not going to give ever the amount of money that these nations are needing, which means that these nations have transitioned the authority over. They're now responsible for administering these services, which have historically been underfunded, and that's exactly what got the federal government in trouble. So I think nations are opened up to a significant amount of liability in that respect. So yeah, I think funding is probably the biggest element for this bill. Basically, if you don't have it, I think you can tear up half of the bill. And if you do have it, you are kind of at the graces of the federal government in terms of what you can afford your children.
Very quick question, Jessie.
Last question.
Good work. Is Bill C-92 better than nothing or not?
No, so I don't think it is better. I think Bill C-92 in its current form just should have never been put out. It never should have been passed. So I did some research for Dr. Blackstock before this research on Bill C-92, but kind of doing a province and territory so province by province and territory by territory comparison of what's afforded under Bill C-92, and if it's any better than what is offered in the other legislation that exists in Canada. And I found on average, everything, the very bare entitlements that Bill C-92 affords are already afforded in every one of those other legislations. So really where the first part of the bill sets these national standards that are designed to fill gaps, the federal government said, oh, we're introducing principles and standards because there's just so much inequity across the provinces, and children are entitled to X, Y, and Z in this province and only X in this province. That isn't true. So I don't see Bill C-92 as serving much of a purpose if under the national standards component, it's not doing anything more. It's not offering anything more. And under the jurisdiction side of the bill is like defunct because there's no money and no way for Indigenous peoples to actually enact jurisdiction. So I think Bill C-92 is not, it's not a positive step forward. It's kind of a useless step forward. I think the bill is just very empty and vague. And I think it was designed to be that by the federal government for a lot of the reasons I've already said. But to answer your question, no, I don't think Bill C-92 does anything good or adds anything.
Thank you.
So yeah, my name is Erika Voaklander, and my paper is on Métis Scrip in Alberta. And my faculty supervisor is Professor Sanderson, and I'm writing my paper also with Zachary Davis of Pape Salter Taille LLP. So first, briefly, like what is Scrip? So effectively, it was a coupon or a note that was redeemable for, redeemable in land that was given in exchange for extinguishing title that half-breeds or Métis had, if any title that they had. And it was issued in 2 waves. The first wave was the Manitoba Act land grants in 1870. The second was under the Dominion Lands Act in Alberta and Saskatchewan. So I'm focusing on Alberta, so I'm going to do the Dominion Lands Act specifically. A not so fun side note is that my family is from Winnipeg Red River area. So my family were Scrip recipients, which I'll get into, but effectively they didn't get any land out of it and were squatters after the failed system. But yeah. So my overarching claim is that I have 3 points I have to make. The first is that Canada had a constitutional obligation to settle Métis claims in Alberta, and then this constitutional obligation engaged the Honour of the Crown. And then Canada implemented this obligation through the issuance of Scrip under the Dominion Lands Act. And Canada's implementation of the Scrip system breached the Honour of the Crown. So this framework is based on the Manitoba Métis Federation case, which similarly found that the Honour of the Crown was breached with the Manitoba Act land grants. So first I have to establish that there was a constitutional obligation. So what I'm basing that off of is that in section 146 of the Constitution of 1867, the Queen admitted Rupert's Land and the Northwestern Territory into the Dominion, and with that admittance, there was this promise, which which is called the Equitable Principles Promise, which reads, upon the transference of the territories in question to the Canadian government, the claims of the Indian tribes to compensation for lands required for the purposes of settlement will be considered and settled in conformity with the equitable principles which have uniformly governed the British Crown in its dealings with Aborigines. So obviously the language is a bit old. So this is the Equitable Principles Promise, which I attempt to argue was breached. So the part of my paper that I haven't quite fleshed out is what exactly these equitable principles that governed the British Crown's dealings. So far, I've not found a clear articulation of what these principles are. But because the principle comes from the Queen and is and contemplates the principles of the British Crown, I have to focus on what the Imperial government would consider as equitable and not necessarily the early Canadian government. I, of course, will have to flesh this out more, but the case law and secondary research seems to be pretty on side that the Royal Proclamation of 1763 is at least informative to what these principles are. And if anyone, or the proclamation stipulates that private land, or there's no private purchase of Indian lands, and alienation can only be directly to the Crown, and purchases have to be to the Crown at a public meeting. So I'm gonna have to flesh that out more, but that's gonna be the basis of what the equitable principles are that the Crown, I argue, breached. Next, I have to, so in order for the honor of the Crown to be engaged, the promise has to be a constitutional one. The promise's constitutionality hasn't really been discussed in the case law, and as far as I know, only until recently by the Yukon Supreme Court and the Yukon Court of Appeal in the various litigations to do with the Dena Council, or the Ross River Dena Council. And in those cases, they did find that the obligation, or the promise, gives rise to a constitutional obligation that is binding on the Crown to fulfill the promise. Before I argue that the Crown breached its obligation, I have to also argue that it applies to Métis in Alberta. So Alberta is within the territory of Rupert's Land and Northwestern Territory that was admitted into Canada in 1870. So that's easy. And then also I have to argue that Métis fall within the terms Indian tribes and Aborigines used in that promise, which I argue is very likely because the Daniels decision says that at the time of Confederation and westward expansion, Indian and Métis were synonymous. And there's other case law that says Aborigines and Indian were used synonymously. So then based off of that, the promise obliges the government to treat Métis in Alberta in conformity with the principles, the equitable principles promise. So the honor of the Crown requires that the Crown act in a way that accomplishes its intended purpose. Its intended purposes and its statutory grants to Aboriginal people. This is what the Manitoba Métis Federation case found. And the Crown, with the Dominion Lands Act, acted to fulfill this obligation of equitable settlement through a grant to land under the Dominion Lands Act. And then the Scrip system was, the Dominion Lands Act was the authority for the Scrip system in the prairies, not including Manitoba. So I will argue that the Scrip system had a number of inequities in the way that it was structured that effectively breached the promise and therefore the honor of the Crown. So the first inequity is how long the process took. So for a Métis individual to go from applying for Scrip and actually receiving land, it was incredibly onerous and convoluted to the point where it defeated the purpose. So briefly, a Métis, the process started with a commission being set up to hear claims by a order in council. And then once the commission was set up, there were sittings across the province, and a Métis individual would have to go there, present the fact that they are a half-breed and that they fit the definition. And if the claim was allowed by the commission, a Scrip certificate was issued to the claimant. This certificate wasn't actually Scrip itself, but it was a certificate saying that they're entitled to Scrip. And then the Métis claimant would then send the certificate of entitlement to the Department of the Interior, which was in Ottawa. And then the Department of the Interior would process the certificate and issue what is called a Scrip coupon. So that's what Scrip is called, or which it refers to as the coupon. And that would get sent back to the half-breed or the Métis person. And then eventually the grantee of this Scrip coupon would have to use it at a Dominion Lands office, which were only in major cities. So in Alberta, they only existed in Edmonton and Calgary until like 1900s. So the grantee would take this coupon to the office and exchange it for land of the amount that was on the coupon, which was either $240 in land or 240 acres. I'll get into the difference between the money and the acre difference. And then eventually the grantee would receive a letter of patent. And of course, this is happening in like late 1800s. So like this process of getting to Edmonton or Calgary, sending stuff to Ottawa, receiving things from Ottawa took a long time. So that process. And then I also argue that the timeline itself was inequitable. So the promise was made in 1867, and then the Dominion Lands Act was authorizing Scrip to be issued was issued in 1879. The first commission in Alberta was in 1885, and there are various commissions that went throughout Alberta that I describe in detail in my paper, but the last claims are heard in 1908. So in the Manitoba Métis Federation case, they found that a 10-year delay reached the honor of the Crown, and here there's at least an 18-year delay plus an incredibly convoluted and onerous process on the Métis claimant to actually receive land at the end of it. So I argue that this combination of delay would breach the honor of the Crown. In addition to the delay, I argue that the availability of land itself was inequitable. So Scrip coupons could only be redeemable for land open for settlement, which meant it had to already be surveyed and available for homestead. But the issue is that Métis in the prairies lived in northern parts of the prairies, but surveyed land started in the southern half of the provinces. So for a large part of this whole process, the land available was on the opposite side of the province that Métis people were in. And this is, of course, was happening at the same time that actual non-Métis settlement was happening in the prairies. So there was a boom in 1882 because of the Canadian Pacific Railway was being developed in Alberta. So on top of having to move to the other side of the province, if they received Scrip, they also had to compete with like European settlers. So I argue that this adds to the inequity. In addition to those things, there was also rampant speculation that was happening. So I referenced the difference between $240 redeemable in land and 240 acres. So that's in reference to you could either get money Scrip or land Scrip. And it was, you chose, the Métis person would choose which one they preferred. And so land Scrip was 240 acres in land, naturally, and then money Scrip was $240 redeemable in land. So at the beginning, land was worth $1 an acre, but it quickly increased to more than that. So money Scrip naturally was worth less. But many Métis chose money Scrip over land Scrip predominantly, because money Scrip was considered personal property, which means it didn't matter whose name was on the coupon. Anyone who bore it could redeem it. So a random person could buy your Scrip from you and redeem it at a lands office. As opposed to land Scrip, it was considered real estate, which means the person who has their name on it had to be present at the land office to redeem it. And as a result of this, this shows that, where am I going with this? Oh yeah, so because Métis chose money Scrip, which is much less valuable, they did it purely so they could sell it, because they know that the process that they had to go through to actually redeem their Scrip coupon for land was incredibly onerous and not worth their time. They might as well sell it for half price and get actually something from it. And I'll get into stats later, but effectively like 90% of the scrip that Métis received were bought by speculators, which were large banks. So like most of the major Canadian banks like CIBC, you name a major bank, they profited and developed based off of earning scrip coupons from Métis people. In addition to the speculation issue, there's also lots of fraud. So like I said, with land scrip, the Métis person had to be present at the lands office to redeem it. But there was this common practice that everyone knew about, including the Department of Justice seen in this memo, that a speculator would grab a random half-breed off of the street to impersonate a Métis that they, on the coupon, so they could redeem the scrip without the person actually being present. So they could buy land scrip, find an impersonator who was Métis or First Nations or anyone really, and to redeem and this happened all the time, and the department knew about it and it was fine. And then on top of that, there's also what they call Dominion lands accounts. So scrip coupons were redeemable or were valued in 240 acres or $240. But if you had a plot of land that you had your eye on that didn't quite meet that, you would just lose, 80 acres or whatever the excess was. But if you were a person holding a large amount of scrip, you could set up an account with the Dominion's office that could accumulate your excess, so you could continually redeeming your excess acres for actual land. But if you're an individual person, you couldn't do that, so you would just lose acres. So this clearly was set up to profit banks and like developers and not Métis people, because Métis people wouldn't go around accumulating scrip coupons from their friends. So again, this argues that this was set up to not benefit the Métis at all. In addition to that, scrip was denied to anyone who fought in the Northwest Resistance in 1885, and then widows and children of those people who fought. Again, this clearly shows that the system wasn't set up to benefit the Métis at all. And I don't even know why they even took the time to add that. Anyway. So the end argument is that all of this system, all of these little things added up to defeating the purpose entirely. So I have a variety of stats that I will include in my paper, but 90% of scrip passed into the hands of the speculators, including chartered banks, private dealers, and only at most 10% were actually used by the Métis. And a vast majority were taken as money scrip, which shows that they just needed that they chose a less valuable option to at least get something from it. And so Métis would sell their scrip for half of what it was worth just to get something, because it took so long to redeem it for actual land. I'm probably not going to get into this because it's beyond the legal scope, but the end result of this whole process is there is a displaced population. So my family wasn't under the Dominion's Land Act and was under the Manitoba Act, but basically a classic stereotypical Métis story is that, so my family was on the L'Oreal Provisional Council, so very politically active and involved in bringing Manitoba into Confederation and thriving, for lack of better words. And then within a generation we were landless and squatting. And so that's a very typical Métis story of being politically active in the West and politically active in the prairies, and then all of a sudden landless and not having no claim to any kind of territory that they once had. So that's what the road allowance people, that's what the common term is for the Métis, is because they just were squatting along the prairies because of how poorly done scrip was. So yeah, that's my presentation.
Thanks so much, Erika.
Thank you, Erika. I learned a lot. I have just a very simple question, I think. What exactly is the legal wrong, and what do you propose as the remedy?
So the legal wrong, I think, let's stop sharing.
I mean, there's so much that's wrong, but what's the actionable legal wrong?
Yeah, so my argument was that it breached the honor of the Crown. So in the Manitoba Métis Federation case, which I guess is very similar to this case, is the court found that the 10-year delay breached the honor of the Crown, and then the speculation and fraud was exasperated by the delay and led to so they didn't find speculation or fraud in itself breached the honor of the Crown, but because there was such a delay, it all added up to breaching the honor of the Crown. So my argument would be the same.
Okay, and the remedy?
That's a great question. So I think this is my own personal opinion, but I don't know if like litigating this point would be worth it because it takes forever, and at the end you just get a declaration that someone breached the honor of the Crown. But I think like currently Métis governments are negotiating with the federal governments, and they have framework agreements, and a lot of these framework agreements include like clauses about negotiating past wrongs or past grievances. So I think this stuff will come in there to like argue for like proper compensation, or because the remedy can't be land because the prairies are settled, and like a lot of the areas that they're looking at are like central, and I don't think all of a sudden displacing the people that have settled in Alberta to like I don't think that's possible. So I think it would come in a more creative approach of like compensation or like something like that.
Okay, thank you.
If that answers your question, I don't.
Thanks, yes.
Erika, I'm curious about one thing from your presentation. This notion of these Scrip transactions with Métis individuals.
Mm-hmm.
How could Scrip transactions with Métis individuals suffice to extinguish a collective Métis title? Am I missing something here?
I don't think you're missing anything. So the orders and councils and the I think it's just in the orders and councils, but in setting up the Scrip system said that it's extinguishing the Indian title of the half-breeds. It doesn't mention anything collectively. It's not delivered collectively. So that's a great question that I should probably get into. Because I guess that could come into the sense that an equitable promise was breached because the Métis weren't dealt with collectively, and the Royal Proclamation says that Aboriginal peoples are supposed to be dealt with collectively. So maybe that helps my argument.
So is it arguable that the statute extinguished the title and the Scrip was an arrangement to settle up and compensate after the fact of extinguishment? Or was the Scrip transaction supposed to be part of achieving the extinguishment?
I think applying for Scrip was supposed to, like when you, I think the idea is, again, they didn't say this when you went to a commission and were signing something that said you were half-breed entitled for Scrip, but I believe the understanding is that when you applied, you were extinguishing any Indian title you had. And that's according to what the like orders and councils that were, again, this wasn't set out in any kind of like formal document. This was just like Department of Interior communication, but I think that's the idea, is that when you applied, you gave up all your title, if any.
Okay, thank you.
Does anyone else have questions for Erika? Erika, I personally found your presentation to be very informative and depressing.
Yeah.
I have a quick question.
Thank you.
Erika,
Yeah, Sarah.
At the beginning of your presentation, you said that your family history involved some of these claims. Did you want to tell us what specifically that was, or would you rather leave that out?
So I guess from what I understand of like the documents I found of my family, we got to the like affidavit section of the, so like when you would go to a commission, you would sign affidavits claiming you're a half-breed that was born between these years. So we went as far as that and didn't go down the line of like going to a land office or mailing it to the Department of the Interior. So we didn't get anything. We also didn't follow through, I guess, either, but it also sounds terribly annoying to try and get land out of it, for lack of better words.
All right, so as you can tell from the title, my paper is looking at infringement of Section 35 rights, and particularly as it relates to conservation and resource use, as well as the larger environmental assessment frameworks. And so I just want to say a little bit before I start, something I really appreciate that Professor Green does in his environmental law class is ask us often to think about land or water that's meaningful to us and how it relates to what we're studying, which I find really helpful for grounding myself in this work. And so Algonquin Park is somewhere for me that is incredibly important. And so all of the photos in my presentation are from Algonquin Park. And it also is a really good example of some of the conflict I'm talking about, because Algonquin Park is the only provincial park in Ontario and one of 2 in Canada, which allows commercial logging within its boundaries, as well as being a place within my traditional territory where I continue to practice my inherent fishing rights, for example, and my family continue to practice their inherent moose harvesting rights. And so for me, a lot of what I'm talking about is quite personal, and the park provides a slight microcosm of some of these bigger issues. So the problem I'm looking to address is conservation is used as a valid legislative objective to infringe Section 35 rights. But research from the fields of environmental science and conservation biology actually show that conservation is more effective when there's Indigenous involvement. And so what we're using to infringe these Section 35 Aboriginal rights would actually be done more effectively if it were done in partnership with Indigenous communities and Indigenous people. And so when I first learned about this, my first thought was, how can we be logically using this to justify infringement when it's not even the most effective way to be trying to meet these legislative objectives? And so some of the science that I'm referring to here, I'll give a few examples. So biodiversity is often higher or at minimum equal in recognized Indigenous land. So for example, in the Canadian context, that would be generally reserves, than in state managed parks in Canada. There's growing evidence that Indigenous managed lands are at least as effective as state managed lands in preventing deforestation. Six Nations has the largest remaining tract of Carolinian forest in Canada, which is one of Canada's most endangered ecosystems. As well as Six Nations still has approximately 50% of its territory is forested, compared to an average of 24 across the rest of the Southern Ontario region. Indigenous managed lands across the world, including Australia, Brazil, and Canada, do have higher biodiversity compared to parks. And in British Columbia, there was an interesting study done that looked at protection of the endangered caribou. And they looked at different methods being used to rehabilitate the population, and found that a partnership between 2 First Nations, which was informed by Indigenous laws and governance in deciding how to go about protecting the caribou in their territory, was actually the most effective recovery effort within the study that included Canada and the US. As policy work should always be informed by science and informed by results, this really shows that Indigenous people and Indigenous laws and governance should be included in conservation work, but that's not what's happening. And so looking at Section 35 more broadly, briefly, it's really important to remember that when talking about infringement, we're not talking about the duty to consult. Section 35 infringement
tests come into effect generally after a government action or legislation has already happened, as opposed to the consultation that'll happen before a project is approved, before some sort of government action. So Section 35 is not actually even within the scope of Section 1, which we generally tend to think of as justification for infringement of rights, because Section 35 is not part of the Charter. And so the court read into Section 35 limitations on these rights in Sparrow, and the test for infringement, after proving that a right exists and that right was infringed, requires looking at whether the government action which infringes the right took place in furtherance of a valid legislative objective, and that the Crown must prove that the limitation to the right was done in keeping with a special fiduciary duty owed to Aboriginal people. So this was the original test for infringement, which has been modified over the years. In Sparrow, in talking about what are valid legislative objectives, the framework that was discussed was the idea that these objectives should be ones which also protect and further the right. So for example, conservation was given as an example because it protects the resource that the right is referring to. Whereas later on in further cases, the court has expanded what can be considered a valid objective, including to things such as economic fairness and non-Indigenous reliance on these resources as well. Furthermore, in Gladstone, the idea of non-internally limited rights was introduced as well. Gladstone was a case which looked at commercial fishing rights, and non-internally limited rights are those rights which, sorry, I'll phrase this differently. Internally limited rights are those which have a limit based on the needs of the Indigenous group claiming the right. For example, a right to fishing for ceremonial purposes has a limit being whatever number of fish that community would need for their ceremony. A non-internally limited right are often economic rights because there's not a limit to how many fish you need to sell. You could in theory sell all of the fish. This approach has been quite criticized in the literature, and I think quite fairly, because there is an assumption that a right to commercial fishing would result in potentially selling all of the fish, which does not give credence to Indigenous laws and governance that would put limits on the access to that resource. But this narrative and this fear about Indigenous rights and Aboriginal rights ties into the narrative around conservation being a justification for infringement. And so from here, after looking at the framework for infringement and the role conservation plays in that, I then shifted to looking at the role of conservation in impact assessments. As Eileen spoke about earlier, there is recent legislation that has changed the framework for environmental assessments in Canada, which was the Impact Assessment Act. And while there are no completed assessments yet under this framework, there are assessments in progress. And so under this act, the factors that are to be considered, which are on the slide here, include several that will relate to conservation, including the extent the project contributes to sustainability, the extent to which adverse impacts are significant, and how it can hinder or contribute to Canada's environmental obligations, as well as potentially the impacts to Indigenous communities and Section 35 rights. And so under this section, I'm looking at both projects that are currently in progress, particularly one example I've been looking at is the gazoduct pipeline in Quebec, which has submitted a tailored environmental impact assessment guidelines, which talk about what will be considered in the assessment when it is decided. And this is helpful in looking at what are the questions they are asking regarding conservation, as well as these other factors for determining whether or not the project will be in the public interest. And I'm also looking at assessments which occurred under the previous legislation that have been decided to look at how conservation is playing a role there. Particularly, I'm looking at the Tsleil-Waututh decision as it relates to the southern resident killer whale, which is listed as an endangered species, and the impacts of conservation there. This is an area of my paper that is less fleshed out currently, as I'm still looking through these two examples and will potentially be adding more. But what I'm trying to determine is, under the Section 35 framework, conservation on its own can be sufficient for infringement. But under the under environmental assessment processes, conservation is simply one factor of the public interest. And so as one factor, how does conservation contribute to the public interest? And I think this is really important to understand, because under the Section 35 framework for infringement, the courts have been clear that a general or vague public interest is not sufficient to infringe a Section 35 Aboriginal right. And yet, conservation under the Impact Assessment Act is only one part of the public interest. So why are there two different frameworks for access to resources, and what does this say about the way we view these two different frameworks? And so my argument is that the way we look at conservation under the infringement framework for Section 35 rights holds Indigenous communities access to the resources in the natural world to a higher standard than we're holding that of the Canadian general population when they engage with environmental assessment frameworks. I think this is incredibly problematic, especially considering the relationship of Section 35 to the honor of the Crown and reconciliation. And I propose that conservation should not be able to be held as a valid legislative objective for infringing a Section 35 right. Again, this is an aspect that I'm still really considering, what does that mean for infringement of rights, and as well as what does that mean for environmental assessment processes that have to be in the public interest? And would removing conservation as a valid legislative objective result in potentially the public interest being considered a valid legislative objective for infringement of Section 35 rights? And that's it. So I'll stop sharing my screen. If folks have any questions or comments, I of course welcome any feedback.
Thanks so much, Leslie Ann. That was excellent.
A thought and a question. The thought is, when you set out what you described as the test for infringement, it looked to me more like the test for justification of an infringement. And you might want to recognize that difference and include in your final product some discussion of what constitutes an infringement in order to set up your discussion of justification.
Yes, you're right. Thank you.
Okay. And the question is, do you know of case law in which infringements of Aboriginal or treaty rights have been held to be justified on the basis of a valid conservation objective? Which I guess is another way of asking, how big of a problem is this really?
So that's challenging, because I found there's a lot of cases that allude to this vaguely, but it's not necessarily made clear as the sole criteria. And so I think I need to do a little bit more review of cases where this is very clearly the issue. But for example, cases around commercial fishing rights, there is a level of conservation that is at issue there because of the idea of a free-for-all, if that makes sense.
Okay, because I'm not aware of a Supreme Court of Canada case where the court has found an infringement of a Section 35 right to be justified, but there might very well be lower court cases that have done so. So talking a little bit about that case law might be helpful.
Yeah.
Thank you.
Thank you.
Leslie, and in terms of the Impact Assessment Act, or two things, I guess, one of which is the Harper government greatly restricted the kind of scope of the Impact Assessment Act to consider issues around that are kind of tangentially related to federal jurisdiction. And so, just as a kind of a comment, you might want to think about it's even worse than perhaps that it first appears, because they're actually looking at only like a minor piece of the puzzle when they're doing that. The question I wanted to ask you is about those factors that the cabinet has to consider. So one of them is the Section 35 rights. One of the factors they have to consider. Is it would it be an improvement to have the cabinet specifically weight that in a particular way, or I mean, these are just these considerations are just put in, and the cabinet has to write reasons about how they relate, but you seem to be finding a relationship between those inside those factors that could be interesting, right? And is there some way in which you can think about resolving that within the legislation itself?
I think I'll have to think about that more, because part of my reluctance in resolving that within the legislation is how easy it is for environmental assessments to conflate Section 35 rights with simply environmental impacts, which the court spoke about in Clyde River. And so I think I'd be reluctant, I don't know the answer to that. And that's kind of my concern with trying to find a way to resolve that solely within the consideration of those factors. Yeah.
No, that's completely fair, and it's hard to know how the cabinet is supposed to be thinking about all this and weighing them off between each other. But it's interesting that you've pointed to this problem within how they've set up the factors. So that's really interesting.
Other questions, Douglas?
No, I don't have a question. I just have a comment, and it concerns your special concern about conservation in the context of selling all of the fish, as though that were a thing that someone might do. And it occurred to me that actually your concern should be more than that. It should be like an Air Canada style concern of overselling all of the fish. You sell all of the fish plus 10%, which apparently is a thing you can do now. So it could be worse.
Okay, yeah.
That's it. That's all. That's my only comment. Is that it could be worse on the overselling the fish.
Could be worse.
Could be worse. Yeah. You could highlight a worst case scenario, because people have gotten themselves into that situation very regularly. That's my only comment.
That's true.
But so I'll get started. I wanted to start with a quick content warning, just because I'm discussing like violence against Indigenous women and the missing and murdered Indigenous women, girls, and Two-Spirit crisis. So feel free to leave or mute or whatever at any time. So as Professor Cook mentioned, I wrote this paper for her course, which is Women in Transnational Perspective. And the course, which Bridget was also in that course, so it's based on, we did like feminist rewriting of judgments in international human rights law to uncover gendered harms in a way that the original judgments don't. And there's a really interesting process to put yourself in the shoes of a judge and really understand the limitations and the potential of judicial decision-making from a feminist perspective. And there's lots of great academics doing that work. So I rewrote the UN Human Rights Committee's decision of McIver, which came out in January 2019. And it dealt with the sex discrimination in Section 6 of the Indian Act, which governs Indian status. And I drew mainly on Indigenous women's perspectives that were expressed in standing committee meetings and Hansard debates and in the National Inquiry Report into missing and murdered Indigenous women in my research. So basically the Human Rights Committee case was Sharon McIver challenging the 1985 amendments to the Indian Act, which was intended to eliminate sex discrimination in the Indian Act. Because before 1985, the Act meant that women who married non-Indigenous men lost status, but non-Indigenous women who married Indigenous men gained status. But the 1985 amendments did not solve that problem. There have been a couple of amendments since, which have also, like in 2011 and 2017, but those still haven't quite solved the problem. So Sharon had 61C status, which meant that she was only able to transmit partial status to her son, Jacob Grismer, and she wasn't able to transmit Indian status to her grandchildren. But her brother, who has the exact same heritage as she does, he's eligible for full 61A status, which means that he can transmit full status to his children, and he can transmit status to his grandchildren as well. So in my rewrite of McIver, I was trying to apply a more robust equality analysis and applying an intersectional feminist framework to the question of whether Section 6 of the Indian Act and the distinction that the Act draws between 61A and 61C status violated Articles 26 and 27 of the International Covenant on Civil and Political Rights. And Article 26 states that it's like a non-discrimination provision. So it says that all people are equal before the law, and it prohibits discrimination on a bunch of grounds like sex, race, ethnicity, religion, etc. And Article 27 says that members of ethnic, religious, or linguistic minorities are guaranteed the right to enjoy their culture, use their language, and practice their religion in community with other members of their group. So the proportionality analysis that I used for my paper requires that a measure have a legitimate purpose or objective, and that the measure is a suitable, necessary, and proportionate measure to achieve the purpose. So it's kind of similar to the Oakes test. And I broke that test down into 4 different aspects in my paper. So I talked about the objective, the strict proportionality, balancing other rights and interests, and remedies. So I'll go through those one by one. So firstly, the objective, the question, like the test or standard here, is whether the differentiation in treatment is founded on a legitimate objective pursuant to the covenant. So the UN Human Rights Committee found that the state's objective was not legitimate. And the state said that it argued before the committee that its objective in maintaining the distinction was to preserve acquired rights, which means that it was trying to preserve the full status of people who are registered under 61A of the Indian Act, which is kind of the more robust version of Indian status. So I argued that this actually wasn't the state's objective, and that the committee should have considered the context and purpose of the Indian Act, especially Section 6, when it was evaluating Canada's objective. So instead, I found that the object of the distinction was to maintain the logic of elimination of Indigenous people by preventing the descendants of the maternal line from maintaining their status. So that's clearly not a legitimate objective under the covenant, because it enacted intersectional gendered harms on Indigenous women. And I argued that in the alternative, if the committee was entitled to rely on Canada's definition of its objective, then the committee was correct in finding that the objective was not legitimate, but it didn't give enough consideration to the intersectional nature of the gendered harms under the proportionality analysis. So I said that the objective was assimilation, because you have to consider the history of the Indian Act and the federal government's intentions in regulating Indian status from the beginning of, colonization when interpreting that objective. So Martin Cannon wrote about the logic of elimination that the federal government has undertaken. And he wrote that the objective of Canadian law has always been to legislatively and physically eliminate Indigenous people or to assimilate them so that settlers could more easily acquire land. And we have pretty clear evidence of that in Duncan Campbell Scott's famous statement that our objective is to continue until there is not a single Indian in Canada that has not been absorbed into the body politic, and there's no Indian question and no Indian department. So that objective is clearly not legitimate because for many reasons, but it was specifically aimed at damaging the intersecting cultural and gendered identities of Indigenous women. And it's had the effect of unequally denying them the right to enjoy culture and community with other members of their group, and so violates Articles 26 and 27. So I considered the historical way that this has played out and also the impact on women more or less today who are affected by the third generation cutoff, meaning that they lost their status because their grandmother had 6-1C status and so they weren't able to transmit it to them. So in this logic of elimination, the Canadian government has deliberately targeted Indigenous women because women often held important social, political, and cultural roles in some pre-contact societies. And so legislators knew that targeting women would be most effective in assimilating Indigenous people. Mary Ellen Turpel has written about this. And the idea was the government wanted to spend as little money as possible on supporting Indigenous people through paternalistic policies. And in terms of the women experiencing a third generation cutoff, I argued that the gendered harms to these women have contributed to the missing and murdered Indigenous women crisis and have to be understood in that context. So this historical Indian Act of sex discrimination is a root cause of high levels of violence against Indigenous women. And the history of Indigenous women's dislocation from communities due to losing status is important context to understanding the gendered and racialized consequences for these women. So this is going to be a drastic oversimplification, but often leaving reserves when women have lived on reserves before makes them vulnerable to abuse because moments of transition can be really dangerous if people are traveling from remote communities, people have a lack of resources, and also arriving in urban centers without a social network and with limited resources can be really dangerous as well. And they might be experiencing poverty and housing instability, both of which makes these women seen as expendable to predators and to the justice system as well. So that's kind of one of the ways that the exile of Indigenous women and their children from reserve communities is directly related to the social and sexual violence that Indigenous women suffer from. And to put that in terms of the covenant, the effect is to unequally deny Indigenous women the enjoyment of a right to culture in violation of Articles 26 and 27. And Article 27 in particular can include the right to live on reserves protected by law. So that's a specific violation that's happening there. So next in the framework is the strict proportionality stage. And the stage, so that standard of the framework that I used asks whether the differentiation of treatment guarantees broadly the objective sought without nullifying the complainant's rights. And I addressed two stages of this, and the first stage asks about the degree to which one of the rights in play has been affected. So I conducted this proportionality analysis, assuming the objective is the one that the government stated, which is the preservation of acquired rights, so preserving people's 6-1A status. And I found that because of the seriousness of the harms to Indigenous women and their descendants, the distinction in Section 6 is not a suitable, necessary, or proportionate measure to achieve the purpose. And I found that the committee didn't consider the intersectional harms that Sharon McIver and the other 6-1C women experienced. And I applied an intersectional feminist framework to uncover the seriousness of those harms in a way that the committee failed to do. So at the first stage, it's considering the degree to which the rights in play were affected. And I drew on Kimberly Crenshaw and Shreya Atri's work on intersectionality and adopting an intersectional approach here is really important in understanding gendered harms facing the Indigenous women affected by the Indian Act, because as Patricia Montour Angus says, understanding how patriarchy operates in Canada without understanding colonization is a meaningless endeavor. And intersectionality allows us to see how Indigenous women's identities at the intersection of sex and race and colonialism make that sex discrimination as a result of the Indian Act both different from and worse than sexism kind of along a single axis. So some of the unique harms that the 6-1C Indigenous women have faced in this context are that this kind of partial status has denied those women the legitimacy and social standing that's associated with full 6-1A status in some communities, and has also forced them to fight for recognition by male Indigenous leadership in some communities as well. So in some cases, Indigenous men have internalized the patriarchal values and governance structures that the Indian Act established and imposed on those communities. So that's led to some Indigenous men replicating Western sexism toward Indigenous women. And Joyce Green described it as patriarchy enacted by the colonial state morphing into masculinism practiced by Indigenous communities to silence women at the local level through the use of tradition as an instrument of domination. And I'm going to skip ahead a bit because I've been talking a lot. So the next stage under the proportionality analysis is the importance of satisfying the contrary right. So I talked about a contrary interest and a contrary right. The interest was the federal government's financial interest in avoiding the costs of reinstating women who lost status. And the contrary right is the potential impact on band governments of an influx of new members coming into their communities. And I found that the satisfaction of these rights and interests did not justify the restriction on claimants' right to equality, and so it was not a proportionate means. So firstly, for the federal government, the consequence of granting the complainant's request in this case would be imposing a significant financial cost on the Canadian government because they have jurisdiction over Indians and lands reserved for Indians under Section 9124. And so they would have to provide more funding because there would be more status Indians. But I drew on the trial judge who decided the McIver case at the BC Supreme Court. And she found that this financial cost wasn't sufficient to find that the provision impaired the right as little as possible. So I adopted that reasoning. She said that purely financial considerations are relevant to determining the standard of deference for the test of minimal impairment, but it wasn't sufficient to justify the infringement of charter rights. And she also found that there was no evidence either at the time the legislation was passed or the time the case was decided of financial emergency or severe financial crisis. And so there was no evidence that the costs associated with granting the relief that Sharon McIver sought couldn't be absorbed by the government. And for band governments, A band's right to determine their own membership is based in the right to culture under Article 27. And Article 27 implicates the power of self-government as well as the band government's concerns about the influx of new community members. But the McIver case really only implicates status registration under the Indian Act. So that's individual Indians' like relationship with the federal government, and not the determination of band membership or the implementation of First Nations powers of self-government. So for that reason, I found that that right shouldn't take precedent over the claimant's rights in this context. That should kind of be a problem for another day. But there are also financial and cultural interests that are part of the band's concerns. So the Grand Chief of the Mohawk Council of Kahnawake said that it creates uncertainty for the future in terms of the people in the community, and they have fears and concerns about people coming in who know and understand nothing about us. It's part of what we call ethnocultural suicide for that to happen. So that kind of shows how whether or not the chiefs were in favor of ending sex discrimination, many chiefs were concerned about the band's financial abilities to meet the needs of these new members who would rejoin their communities through reinstatement as a result of ending sex discrimination, and also just any conflicts from people who hadn't lived on the reserve coming in to that community. But addressing this concern by refusing reinstatement only to women and matrilineal descendants would just be continuing the sexism written into the Indian Act. So I argued that given the current financial or the current relationship between the federal government and band councils, it's the federal government's responsibility to ensure that the bands have enough funding to fulfill their community's needs, even with the population increase that would come from removing that discriminatory distinction. So I also talked about remedies. The remedies the committee ordered, so the committee did decide in favor of Sharon McIver, and it granted 2 remedies. One was allowing everyone who was previously ineligible based on sex discrimination to register under 6.1a, and also taking steps to address residual discrimination within Indigenous communities arising from sex-based discrimination in the Indian Act. So given that we're operating under the Indian Act, which is limited in itself, and given the committee's limited power to interfere with domestic laws, I found that those remedies were adequate. But it's also important to note that working under the Indian Act comes with major limits in terms of the potential for transformative equality in remedying gendered harms to Indigenous women through the Indian Act. In particular, I argued that First Nations should be given jurisdiction over their own matters of identity and citizenship, and maintaining the Indian Act as a means of dealing with citizenship won't achieve transformative equality for Indigenous women, in part because the Indian Act has acted as a colonial tool for so long to impose patriarchy on Indigenous communities. But I also discussed some temporary special measures that could go some way toward remedying the intersectional gender's harms. I took a prefigurative approach to remedies that aim to inspire domestic law and policymakers to strive for substantive equality for Indigenous women in Canada. So prefigurative or prefiguring is an idea that Hilary Charlesworth describes, and she defined it as the adoption of structures and styles of reasoning that one is promoting, or a modeling of desired social and political outcomes. So basically being the change you wish to see in the world. And so to that end, I borrowed some ideas from the National Inquiry Report into Missing and Murdered Indigenous Women, and suggested funding in different Indigenous languages for Indigenous women living off reserve, and funding for Indigenous youth to return to a home reserve and participate in land-based and language education. So that is all. So if you have any questions or comments, please let me know.
Wonderful. Thank you, Lauren. Why don't we let Rebecca and Cheryl go first for questions, and then we can open it up.
Force. My comment, I have 3 comments. One.
Sorry, Rebecca.
Yes.
I had you muted. I muted you. So maybe just start from the beginning. I'm so sorry.
Okay. Sorry. Lauren, congratulations. That was a real tour de force. And I really like the way you've developed your paper since we last discussed it. So it's really very, very well done. I have 3 comments. One relates to the proportionality analysis. And the second relates to the structural nature of this particular kind of discrimination. And the third relates to remedies. So on the proportionality analysis, in rereading your paper this morning, I thought, why in the sections in where you talk about balancing, the pages, let me just give you the pages 25 to 33, you went into financial considerations as opposed to looking at the interest of preserving the acquired rights under 61A that the state alleged. My concern about going into the financial considerations is that that's something that usually international human rights treaty bodies don't deal with. That's too detailed for them. They try to deal at a higher level of abstraction. And it might have been more useful had you just focused on the state's argument, the state's interest in preserving acquired rights. And you might have been able to bring in more of your analysis from the beginning of your paper on intersectional gendered harms, which was extremely well done. So that's my first comment on the proportionality analysis. I should have started by putting this in a broader context. These decisions are addressing an international audience as opposed to a Canadian audience. So making them accessible to that kind of audience is another reason why human rights, regional and international human rights treaty bodies try to give a view of the forest and don't get into the issues that, say, the Supreme Court of British Columbia got into about the financial issues. The second point, what is extremely important about this decision, which you point out, is the structural nature of discrimination. And following up on your point about Hillary Charlesworth sort of envisioning what rights might be what rights might look like in the future, prefiguring rights. We need so much more work in thinking about the structural nature of, particularly of the intersectional discrimination. And you allude to this by the fact that the Indian Act, their goal is to assimilate, and how the lack of assimilation has led to violence against women, has led to masculinism in the Indigenous communities. But had you really brought together the insights that are integrated throughout your paper on the structural nature of discrimination, that would have advanced international human rights law in terms of thinking about the structural nature of discrimination. On remedies, my third and last point, on remedies, I really liked the imaginative approach. You're really following the Inter-American Court in their imaginative approach to remedies, and pushing the Human Rights Committee to think in far more creative ways by ordering the government to develop and issue a documentary on Sharon McIver. That's specific, and it brings in all the issues about the intersectional nature of the harm. And remedies at the international level are most effective when there's a specificity to them. But they're also most effective when they relate it. And here I want to relate to some of the work that Cheryl Zuzak has done in her article, when it's related to the kind of reparative justice, what you're trying to aim at in ordering that kind of remedy. And here you mentioned the transitional nature of justice, Cheryl's work in her article on using transitional justice as a model. And also she refers to Douglas's work on corrective justice. So by relating that call for the government to develop a documentary on Sharon McIver to the kinds of justice you're seeking really makes that extremely powerful. Now, on the other remedies that you ordered, classes on Indigenous languages for Indigenous women living off reserve, and Indigenous land-based education and language education for people returning to reserves. That, while I think the objective is fine there, it's going to be criticized because it doesn't have a specificity. How much education, how can you make that a bit more concrete? And you see this debate going on in international human rights literature, advocates looking to decisions and criticizing them because they don't have specificity, because then they can't hold the governments accountable. They're always trying to look to these remedies as a way of finding a hook to really hold governments accountable. So those are my three comments on what is an excellent paper and an excellent presentation. And I do hope you will develop it. Cheryl, over to you.
Hi, everyone. Thank you so much for letting me join you. I haven't read the paper, and I'm absolutely new to your forum, so it's a real pleasure for me to be a guest. Thank you. I thought the presentation was excellent, and I had two questions / comments about the analysis that I would like to ask. And again, I'd like to emphasize my admiration for the work you've done, Lauren, in the paper. It sounds fantastic. The presentation was gripping and really, really exciting and interesting to listen to. I'd like to talk specifically about harms and remedies after first talking about how you define the issue. And I'm curious to know if you considered in defining the issue, looking at prior decisions by the UN committee, especially the Sandra Lovelace case, where they say explicitly that there's no place in Canada where an Indigenous woman can be Indigenous in terms of her tribal identity beyond the reserve. There are places that are where it's possible to assert Aboriginal rights in a general framework or participate in generalist practices of Aboriginality, but there's no place where being from the Tobique Reserve in the Tobique cultural context is expressed with greater focus and opportunity and sort of existence than on the Tobique Reserve. I wondered if there's a way to open up another path of analysis from that framework by the committee itself in its own recognition that it isn't the first time, in fact, that they've seen a case on the question of Indian Act status. In fact, they've already talked about that at some length and looked at the concentration, but not in terms of financial instabilities, but in terms of cultural rights and cultural access. So that if you're taking the state's position that they're protecting entrenched rights through 6.1 status, are not those rights also cultural rights through the Indian Act that also require protection? And is not the right of cultural status, rights, and identity within the reserve itself not a framework worth protecting? So that's one kind of path of analysis that I think would be really opening up a certain kind of recognition that the reserve is not a place of deficit or inhibition the way the state tends to view it in terms of its protection after the fact of having depopulated it through different amendments to the Indian Act, but rather what, from a ground up analysis, Indigenous communities have done on reserve to ensure the continuation of cultural rights. And the idea of cultural rights, I'm asking because I think it's so exciting the way you've put together in such clear ways the complementarities and the sense of intersectional power that both tribal governments and the government share when you talk about financial disparities or financial commitments. The financial is the ground that Indigenous women lose on because, in fact, they're not in positions of power to dictate how financial concerns will be defined and addressed. And I'm wondering if, again, you could come back to this notion raised by the Grand Chief about ethnocultural suicide and argue that there's an ethnocultural gender genocide attached that is more accurately premised in the distinction made against Indigenous women that then has a kind of corollary effect for Indigenous women and their descendants, so that there are two paths towards ethnocultural identity. One is the path of a kind of homogeneous, taken for granted patriarchal identity, and the second is a kind of gendered, discriminatory path that's built into the way the amendments have in fact eroded women's presence on the reserve. And out of that idea of the ethnocultural gender disparity, the harm would then come back in as perhaps an idea of restoring what's been taken on the very grounds of the Grand Chief saying it's ethnocultural suicide for us to bring all these people back who have no knowledge of our culture, our language, and our identity. Could a reparation then be one idea about the government will provide reparation by restoring to the communities opportunities by which they can speak about the gender dimensions of their culture and traditions, the gender dimension of the human rights that they would like to see associated with men and women in kind of intersectional forms. But so the human rights that are in place that require protection, the human rights that attach to Indigenous peoples as defined by Indigenous peoples, and then some reparative aspect that places and acknowledges that indigeneity is not about a kind of hierarchical Canada versus Native peoples, but is about Indigenous peoples in association and alignment with other tribal communities. So it would be, how does UNDRIP provide human rights that then are tribally specific human rights or band-specific human rights? And how is the reparative framework and education opportunity put into place that would allow for an alignment among tribal peoples in terms of the gender-based human rights of Ojibwe people, the gender-based human rights of Mohawk people, and that if those are put in place, is that argument going to move us away from the financial costs that the government would object to, but rather speak back to the government on the grounds of what it says it's trying to protect, which are human rights? So an education initiative that would allow for the restoration of those different already existing, but seemingly under assault by returning community members, an opportunity to shore up those places where remedies actually take the form of education and take the form of cultural distinction, but take the form of cultural restoration and a goal towards reconciliation, because then the whole community participates in those discussions. So those were some of the thoughts that I had based on very fascinating and interesting paper.
Thank you so much. Yeah, those are really helpful comments, and I'll definitely be interested to look into those further. So thank you very much.
Great. So any questions for Lauren?
Just one thought, Lauren. Let me first agree with Rebecca and Cheryl that this was really good work. The one thing that struck me that I wondered about in listening to your presentation, at one point I thought I heard you say that the purpose of the registration scheme in Section 6 in the Indian Act, in the form in which Sharon McIver encountered it and complained about it, was ongoing assimilation. And my problem with that is that it's difficult to square that view with the 1985 amendments, which restored Indian status to a whole bunch of women and a whole bunch of people on a variety of grounds pursuant to which they had been excluded before 1985. And if the sole or the primary purpose of the registration scheme was assimilation, it would be hard to explain reintroducing a whole bunch of people into the camp of people who have Indian status. I don't think this issue affects the overall strength of your argument, but I think it's a little harder than it sounds like you think it is to make an argument about assimilation being the goal of Bill C-31 insofar as it increased eligibility for Indian status in 1985.
Right,
actually,
yeah,
I want to
oh, sorry.
Oh, no, sorry, Lauren. I just want to hop in on exactly the same point, which is just that I'm not sure that assimilation is actually the right word here. I mean, clearly this is about eliminating Indian identity, but it's not like, and you become a citizen, or, and you get a guarantee of mobility rights. Like, there's no welcome to Canadian culture assimilation thing going on. It's just, you're not an Indian anymore. So I'm not sure that's the right word to use. And my second comment just concerns something that you said as a problem for another day, which is, I think if I understood, this question about, is the federal crown the right place for making decisions about who is and who is not an Indian, and that maybe there are a group of people, probably men, who think that that decision more rightly resides within the community itself. And so while, there's nothing to resolve here, I was just curious about your comments or for your thoughts on that as an issue. Also, great work, and it's nice to see you again, Lauren.
You too. Yeah, thanks for those comments. That's both really good points. And I agree that assimilation on reflection is probably not the right word. And I think, yeah, I was drawing on the logic of elimination idea, which I think puts it better rather than assimilation per se. And just also to Carrie's point as well, I think in framing the objective that way, I was mostly talking about the pre-1985 legislation, but also I think I was struck by the reluctance that the government faced at every stage. Like, there's been a series of amendments to the Indian Act, I think 3 now since 1985. And there's never been a point, it just feels very much like they're litigated into having to do something about it, and it's always kind of like the bare minimum from what I understand. I could be wrong with that, but that's something that Sharon McIver expressed as well, that at every stage it's just kind of the bare minimum of what the court has required of the government in terms of expanding the number of people who get status. So to me, that demonstrated a reluctance to really kind of go crazy with letting everyone have status, which I think would have been a better way to approach it. But that was kind of my thought process, but definitely point well taken that that isn't totally maybe the objective as much as I was seeing it. And on your second, sorry, could you repeat your second question? Oh, maybe he's gone. But yeah, I thought that it was, it's definitely
Oh, sorry, Lauren, were you asking me or Carrie about our second point?
You.
Lauren with the second question.
Yeah.
So my second question concerns the matter for another day, which is the question of whether the federal crown is the appropriate body to be determining membership in First Nations communities, or whether that is a discussion more appropriately based in the community itself.
For sure, yeah, that membership is, I think, something that should be determined by the community. An interesting dimension was that I did this research a while ago and I'm trying to remember this correctly, but I believe like some of the male chiefs were arguing that this is the opportunity to deal with self-government concerns and transferring membership to the community. And the federal government was kind of capitalizing on that to engage in these consultations with like different communities before implementing these changes to just like the status provisions, which is what Sharon McCover was asking for at the Human Rights Committee and before. So it kind of seemed, I think a lot of Indigenous women who were fighting this perceive that as kind of a tactic to delay dealing with just the status issue. And so if you separate those two out, you can just deal with the status issue, which is arguably more straightforward, and then kind of take whatever path is appropriate for dealing with membership and citizenship, if that makes sense.
Thank you.
Great. Any other questions for Lauren? Excellent work, Lauren.
My topic's a bit similar to Kiran, who presented first today. Like her, I'm writing my Stirrup and Professor Wilkins' Aboriginal Law Practicum course, where we've been discussing the Desautel decision in depth. And like Kiran, I was drawn in by the Crown's argument or use of the doctrine of sovereign incompatibility as a way to stop Aboriginal rights claims at the initial stage of the Van der Peet analysis. And instead of looking at it a bit more broadly like Kiran did, I chose to select an Aboriginal right that on its face appears to be the most threatening or problematic in terms of sovereign incompatibility. So that right is the right of self-government. So I decided to explore that specifically. In terms of my research question and thesis, the research question I sought to answer was, does sovereign incompatibility constitute a legally defensible bar or limit on the assertion of an Aboriginal right of self-government under Section 35 of the Constitution Act 1982? And my thesis was that an Aboriginal right of self-government understood as personal jurisdiction, which I'll get into later in my presentation, can exist alongside factual Canadian sovereignty without raising concerns regarding sovereign incompatibility. So in terms of the structure of my presentation and my paper as well, it's divided into 4 broad sections. So firstly is looking at imperial constitutional law, and more specifically, the doctrine of continuity. I found that examining the origins of the doctrine of continuity provides a really solid foundation for how the concept of continuity has been applied within Section 35 jurisprudence. And as I'll discuss, it's been fairly distorted between what imperial constitutional law has viewed continuity as and what the Supreme Court of Canada has applied it as. And next, I examined Section 35 in detail. So I looked at its development, and in particular, the Van der Peet test and how that's structured, how self-government claims have been viewed under Section 35 at the Supreme Court of Canada, and then how sovereign incompatibility fits into the jurisprudence, if at all, and kind of looking at what role that has played in the courts to date. Next, I addressed sovereign incompatibility as a potential barrier to the Aboriginal right of self-government, and looking at what arguments can be used by Indigenous claimants to show that a right of self-government doesn't actually threaten Canadian sovereignty. And then finally, I'm ending on kind of an alternative avenue or a potential pathway forward looking at the possibility that common law Aboriginal rights potentially provide a more welcoming space for the right of self-government than Section 35 jurisprudence, especially if the doctrine of sovereign incompatibility eventually plays a greater role in Section 35 analyses. So I'm going to end kind of on that note of possibility for the future. So first, looking at the role of imperial constitutional law in all this, and the doctrine of continuity more specifically. The doctrine of continuity holds that the laws in place in a colonized territory survive the assertion of sovereignty unless altered or abrogated. And this doctrine is subject to 3 exceptions, which the Supreme Court of Canada outlined in the Mitchell decision. And these are when the previous laws are incompatible with Crown sovereignty, which is the doctrine that I'm examining in my paper, when they're ceded, or when they're extinguished. And then when looking at the doctrine of continuity and imperial constitutional law more generally, it's really important to look at how sovereignty was asserted or acquired in the first place, because that determines the role that the doctrine will play. And in Canada, it's a bit confusing because the Supreme Court of Canada hasn't really made a firm statement on how the Crown acquired sovereignty. They've rejected some methods, as I've listed here. In Haida Nation, they state that Indigenous peoples were never conquered. In Silcoteen, they rejected terra nullius and the doctrine of discovery. So I propose using this concept of complex settlement as a potential theory. So Mark Walters brought forward this view of differentiating between simple and complex settlement. Under simple settlement, there's only one legal system in place at a time, and Indigenous legal systems would have no validity unless positive law recognized it. Whereas under this idea of complex settlement theory, it's based on this idea that it would be inappropriate for one legal system to encompass 2 vastly different cultures or peoples, or more than 2. So it kind of has this view of recognizing cultural and legal pluralism. And this idea brought forward by some other scholars that when colonizing territory, the British only brought with them as much law as was necessary to fill in the gaps. So where there was Indigenous legal systems in place, those laws continued because there wasn't a need for a new set of laws. So under this idea of complex settlement, the doctrine of continuity would apply, which has this basis, which sort of recognizes legal plurality. And then to kind of show an example of this, I used the case of Connolly and Woolrich, which was a case decided very soon after Confederation, where Connolly married his first wife under Cree customary marriage law, and then later on in life had a marriage ceremony under Roman Catholic traditions. And the case arose based on a child of his first marriage who was arguing about which marriage was valid and whether children from his second family should be able to benefit from Connolly's estate. And the judge upheld the validity of customary marriage conducted under Cree law and pointed to, among other things, the fact that the Indigenous people's rights and traditions continued in force after sovereignty, and also pointed to some of these practical difficulties of expecting, in this case, Cree peoples to travel different distances in order to access ceremonies under a different legal tradition. So this kind of points to an example of this idea of complex settlement and there being multiple legal systems in place and both being recognized as valid. So I use this as a starting point in my paper to show that the doctrine of continuity, to show how the doctrine of continuity functions, the fact that it was recognized by the Supreme Court of Canada in Mitchell, and possibly on the basis of complex settlement, which recognizes cultural and legal pluralism. And then moving on to the next section of my paper, we see how this conception of continuity has been distorted by the Supreme Court of Canada to the detriment of Indigenous claimants. So looking at Section 35 now, and more specifically, the Vanderbilt test, I'm arguing in my paper that it shows a marked departure from the doctrine of continuity. So under that test, it's looking at the continuity of practices, customs, and traditions. And whereas under the doctrine of continuity, that was looking at the continuation of legal systems in their entirety after the assertion of sovereignty. So already this is problematic in terms of limiting rights which can be recognized and affirmed. And if you look at the dissents in the Vanderpeet decision by Justices McLaughlin and Laura Dubé, they point to this gap between what the doctrine of continuity says and what the majority was stating is the appropriate test for determining Aboriginal rights, and how there's a bit of a gap there. So that was even noted by judges at the court. In terms of what this means for self-government rights specifically, we know that in the case of Pamajawan, the court stated that self-government rights are like any other Aboriginal right, and that they have to meet the Vanderpeet test as is. And we know that in Pamajawan and in Delgamuc, the broad self-government claims were found not to be cognizable. So in effect, what this means is that I call it an empty box of jurisdiction, in that Indigenous groups bringing forward claims of self-government have to do so in a very piecemeal way, claiming or filling one area of jurisdiction at a time. And this is obviously extremely problematic for multiple reasons. It's costly to bring forward litigation, it's extremely time consuming, and it's also problematic in the sense that the Supreme Court of Canada has already recognized the fact that prior to the assertion of sovereignty, Indigenous peoples were living in organized societies with their own legal systems. So for that reason, it seems problematic not to recognize self-government rights as is, and to need to break them down into smaller areas of jurisdiction. So based on how the Supreme Court of Canada has looked at self-government rights, I tried to question where, if at all, this concept of sovereign incompatibility fits into the discussion. So as I mentioned, under the Vanderpeet test, Aboriginal rights need to be cognizable to the Canadian legal and constitutional structure. And the Supreme Court of Canada has not really given meaning to what cognizable means. So I'm arguing in my paper that they have taken it to mean compatible with Canadian sovereignty, and that this is why these broad self-government rights have failed at the initial stage without actually going through the Vanderpeet test. And so essentially I'm arguing that if sovereignty is understood to mean that there is one supreme governing authority that makes all decisions over territory and the people inhabiting it, any claims that require reading down that sovereignty would be viewed as sort of a threat to the state. And this is a view that Mark Walters also takes. And there's some support for this in the case law. When you're looking at the meaning that the court has ascribed to reconciliation, it's often phrased in the way of Aboriginal rights or interests being reconciled with Crown sovereignty or Canadian sovereignty, rather than the other way around. So this kind of idea of Aboriginal rights needing to be read down in order to be compatible with sovereignty. And I feel like it really needs to be asked what about self-government rights, or whether self-government rights really are these threats to Canadian sovereignty. And I know there are certain instances that Kiran also discussed in her presentation about military forces, border control, that may seem to border on this threat to sovereignty. But I will be arguing in my paper that those concerns can really be taken into account under the infringement justification analysis, and don't need to pose right at the beginning a barrier to self-government claims. And that by stopping these claims at the beginning, they're also stopping any other form of self-government, which could be personal jurisdiction, which I'm not arguing is the correct solution in all situations, but according to a lot of scholars, it's potentially a step, the right step forward before asserting territorial sovereignty, which could be more difficult. And with personal jurisdiction, you're looking about power over individuals on the basis of their membership in a certain group. So these other concerns about international personality don't really arise. So I find that stopping these self-government claims at the very beginning of the analysis is highly problematic for that reason. And I'm also arguing in my paper that it's possible to give a different meaning to cognizable that would allow self-government claims through the analysis, and then address these sovereign incompatibility claims at the justification stage or infringement justification stage. And if you look at a different area of Aboriginal law, that being the fiduciary duty, and looking at the common law more generally, the meaning that has been given to cognizable in terms of looking at laws and legal systems is being intelligible, specific, recognizable. And there is some discussion in scholarly works about the fact that imposing this higher standard of cognizable, or this different meaning of cognizable in terms of looking at self-government rights and Indigenous legal systems is highly problematic, given that there is a much lower standard in other areas of the common law. So that's kind of what that section is examining. So my key takeaway here is that the Supreme Court of Canada appears to be applying sovereign incompatibility at the initial rights defining stage of the Van de Putte analysis in order to effectively stop broad claims of self-government, and that it's possible to draw a more supported meaning from case law in other areas to give the term cognizable a different meaning that would allow these broad self-government claims in at the initial stage, and then allow for any sort of limitations at the infringement justification stage. So that's essentially my argument from this part of the paper. And then when I move on to sort of countering sovereign incompatibility, the idea here is that should cognizable be taken to mean sovereign incompatibility and continue to be taken to mean that way, there are potentially avenues for Indigenous parties to bring forward arguments to counter the idea that these self-government claims are really a threat to Canadian sovereignty. And I have sort of 4 broad arguments that I use to counter this idea. The first is looking at the idea of Crown sovereignty as de facto rather than de jure. So as mentioned by Kiran as well, in the decision of Haida Nation, the Supreme Court of Canada referred to Crown sovereignty as de facto and just assuming de facto control over the territory. And this speaks to the idea of practicality, the idea like that the Crown has factual control is a necessity, perhaps to avoid a legal vacuum, but it's not, it can be contrasted to de jure or legal sovereignty. So the point of this isn't to say that we should do away with Canadian sovereignty or Crown sovereignty, because that poses its own problems in and of itself, but it opens the door to the idea that the court is now really willing to begin questioning or critically analyzing at least how sovereignty was asserted, and kind of gives space in that sense for the potential of Indigenous self-government being recognized under Section 35. There are some scholars that argue that because Crown sovereignty is considered to be de facto, that Indigenous sovereignty is actually de jure, and in order for Crown sovereignty to be considered legal or de jure, it would need the consent of Indigenous parties. So that's one extreme end of this argument, but I think at the very least, it leaves room for the possibility of Indigenous self-government and could be a potential argument that could be made. My second consideration is there are some academics who believe that Section 35 marked a new promise and therefore a new assertion of sovereignty on the part of the Crown, and that this poses new considerations for applying the doctrine of sovereign incompatibility, if at all. So it's the idea that this new assertion of sovereignty is what Aboriginal rights must be reconciled with or compatible with. And because Section 35 is premised on this idea of reconciliation, it's possible that self-government claims under this newest understanding of Crown sovereignty would be more welcome in that space. And it really hinges on how reconciliation is defined, which is a complex topic in and of itself. But if you're really looking at flipping around what's reconciled with what, so looking at sovereignty being reconciled with either Indigenous sovereignty, which is a complex notion in and of itself, or Indigenous interests, or Indigenous legal systems, that's potentially another pathway forward for countering this idea of sovereign incompatibility. My third argument in this section is looking at Aboriginal title as a partial recognition of self-government. there are, if you look at the decision in Delgamuck, the court stated that Aboriginal title cannot be held by individual Indigenous persons. It's a collective right, and decisions with respect to the land also have to be made collectively. And there are some, again, scholars who have argued that, though in Delgamuck, as I said earlier, the court rejected these broad self-government claims as being not cognizable, how Aboriginal title was set out sort of implicitly shows at least a partial recognition of self-government over the lands in question. There's definitely limits on those rights, but it begs the question sort of, if the court is willing to allow this form of, if we call it self-government over certain lands, what's the major difference between allowing these broad self-government claims? So I thought that that was an interesting argument that I found in literature to use in this section. And then finally, my final argument in this section is about legal pluralism, which I talked about a bit at the beginning of the presentation when examining the doctrine of continuity and complex settlement. I decided to look at examples in both the US and Canada about how there's a possibility for having multiple legal systems under one federal sovereign without there being concerns about sovereign incompatibility. So in terms of the states, tribes are viewed as domestic dependent nations who have residual sovereignty, which is subject to the plenary power of Congress. So I'm not saying that this is an ideal model. There are many criticisms of it, including the fact that it is subject to plenary power of Congress, and even the term dependent nation is highly problematic in and of itself. So it's not necessarily an ideal model for Canada to consider, but just the idea that it's possible for there to be, in this case, multiple sovereigns under one federal sovereign with that work together and have different areas of jurisdiction. And then in Canada, I'm looking at customary marriage, like in Connolly and Woolrich that I discussed earlier, and customary adoption. And I am potentially going to look at sort of civil and common law systems as examples of legal pluralistic traditions within Canada itself that show a willingness or an openness to consider multiple legal systems under one sovereign, which I think kind of points to sovereign incompatibility not being a really strong argument, at least at the rights defining stage, as it has been, I'm arguing that it has been used. And then for my final section, as I mentioned, I was going to be looking at the place or the role that common law Aboriginal rights can play in this discussion of sovereign incompatibility and self-government. Should Section 35 end up proving not to be a welcoming space for these self-government claims? So there's a possibility that even if self-government cannot be asserted under Section 35, it exists at common law and can be enforced in the courts under this route. There are a couple of statements by the Supreme Court of Canada that seem to potentially counter this argument, that, and these statements seem to suggest that Section 35 encompasses a broader scope of rights than those existing at common law. These statements are found in Delgamuck and Mitchell, which state that even Aboriginal rights that existed at common law were recognized and affirmed under Section 35, but that Section 35 also encompasses other rights on top of those that existed at common law. So suggesting that it's much broader in nature. However, as discussed earlier when looking at the Vanderpeet test, it does impose fairly strict requirements of specificity and cognizability. So it's difficult to reconcile this broad scope with the Vanderpeet test. So there are some scholars, including Mark Walters and Kent McNeil, that have put forward the argument that common law Aboriginal rights, though potentially not as broad in scope, do encompass different rights than those that are recognized and affirmed under Section 35. These authors point to the fact that the courts seem to be using the constitutionalization of Aboriginal rights as a means to justify those specificity requirements. So the idea that Aboriginal rights are only held by Aboriginal peoples of Canada, so a limited scope of people within Canada. So they have to be defined narrowly and specifically. So under this kind of idea of Section 35 rights needing to be more specific, it's possible that the common law, it would be more welcoming to a broader right like self-government. So the idea here is that if the FCC continues to reject broad self-government rights at the initial stage of the Van der Peet test, due to these cognizability and specificity concerns, there is this potential for an alternative avenue to assert that right that is grounded in this idea of imperial constitutional law and the continuity of legal systems at common law, and the fact that that the doctrine of continuity has already been recognized by the Supreme Court of Canada provides a bit of a foundation for this argument as well. So that's it for my presentation, subject to any questions.
Well done, Bridget. I take back that Erika had the hardest shift of or slot of the day. I think that you did, and you did a very excellent job talking, as Kiran did, about something that is very complicated. Mm-hmm. Having taken Carrie's class many years ago, I still find Section 35 very difficult to understand. And you did a great job of presenting your ideas in an accessible way, and I really appreciate that. I'm sure Carrie and Douglas have lots of questions for you, so I'll hand it over to them. Oh, Douglas maybe not doesn't because he's gone.
So my first thought is that it would be really good for Bridget and Kiran to talk, because there are quite a few things you seem to agree about and a few things you seem not to agree about. But we don't seem to have Kiran anymore. Oh, there you are. Okay. So if you haven't already had a chance to talk, I will let you talk now before I ask my questions. But if you have another chance to talk offline, I'll go ahead.
Yeah, I think we're going to organize a time to kind of chat about our respective papers at a different time. So,
Kiran, that's okay with you? Okay. Where to start? Okay. I guess my first question is, if sovereign incompatibility turns out to be a problem for a Section 35 self-government right, why wouldn't it be at least as much of a problem for a common law self-government right?
Well, I think the argument that I'm bringing forward is that under the Van der Peet test, they've incorporated different requirements than would exist at common law. And I think as well, the fact that, I'm trying to rephrase this. So I think using the doctrine of continuity and those three exceptions that I outlined that were listed in Mitchell, as long as I think that the way that the Crown or the Canadian government has had relationships or dealt with Indigenous peoples to date has recognized a certain level of either sovereignty or self-government in a sense. So it'd be difficult for them to argue that at the assertion of sovereignty, those legal systems were incompatible with their sovereignty. So I think on that basis, it could be argued that the doctrine of continuity allowed the legal systems to continue to date, and that there are less, as I mentioned, the specificity requirement under Van der Peet wouldn't be a barrier under the common law. So I think that's how I think of the potential argument being made for that question.
Okay. So you could be saying one or potentially both of two things. You could be saying that there's no such doctrine as sovereign incompatibility as it applies anymore, which is, I think, kind of what Kiran wanted to say. Or you could be saying there is such a thing as sovereign incompatibility, but a right of self-government is or could be compatible with the sovereignty of the Crown.
Yeah, I think I'm more making the second argument.
Okay.
Yeah.
So there might be some stuff that is incompatible with Crown sovereignty, and for that reason, couldn't be a Section 35 right, but self-government isn't one of those things.
I think I'm more saying that it shouldn't be applied at the initial rights defining stage as it has been, and that those really broad concerns that have already been mentioned in the case law, such as military forces, border control, having sort of an international personality, those concerns could be examined within the limitations stage of the analysis, because that step of the analysis already incorporates these considerations of concerns of broad public interest. So I feel like if it's going to be used, it would make more sense to use it at that stage rather than blocking all self-government claims that aren't done in a piecemeal way at the initial rights defining stage.
Okay. I think from time to time about paragraph 44 of the Voaklander case, which you may remember we talked about in class last year. What Justice Binney said there about Pamajuan was that the court in Pamajuan was sizing the Aboriginal rights claim, which was initially framed as a self-government claim, to fit the more specific circumstances of the facts of Pamajuan, and to protect Pamajuan from claiming a bigger right than he needed in the circumstances, sort of doing the usual Supreme Court size to fit characterization dance, and that maybe cognizability wasn't any more than that. So if that were right, then maybe this notion of cognizability wouldn't be a substantive bar to a self-government claim in another case on different facts. What do you think about that? Or do I need to translate that into English?
So I think what you're saying is that if on a different set of facts, the court characterized the right as needing to be framed in broader terms, then maybe they would accept it at the cognizability stage. Whereas in Pamajuan, they were saying that what they really needed was like a narrower right, so that's why they recharacterized it. Is that what you're getting at?
Kind of like that. I mean, you see, for example, in Adams, which was pleaded as an Aboriginal title case, but was really about fishing. The Supreme Court saying, you don't need Aboriginal title to get off this fishing charge. It's enough to have a fishing right. And the evidence supports a fishing right. In Pamajuan, according to Justice Binney's thinking in Voaklander, the court's making the same move, only Pamajuan still lost. So there might be a case, I mean, we know now that there are cases where Aboriginal title is the correct right to be claiming because Silcoteen succeeded doing that. Might there be a case in which self-government is the proper right to be claiming where it could be established, and cognizability, understood in this kind of size to fit way, might not be a barrier?
I have trouble thinking of a set of facts where the court wouldn't take it upon themselves to narrow the right and recharacterize it, because they've often done the recharacterization bit not even to the benefit of the Indigenous group. So I have trouble seeing a set of facts where that would happen. I mean, it's a possibility, but I have trouble imagining that set of facts at the moment.
So that might be an independent problem for a self-government right, irrespective of what we say about sovereign incompatibility.
Yeah, I think that's fair. I'm going to consider that in more detail. That's a fair point.
I think those are all my questions at the moment.
Great. Well, I am aware of the fact that it's almost 3 o'clock, so we're a little bit over time, or we're over time a little. Sarah, do you have any concluding remarks as the director of the certificate program? Maybe you could sum us up. Well, not like sum us up, but. Oh, you're on mute.
I was saying no. I mean, I'm just so impressed with the quality of these papers every year. I'm not joking. It really is one of my favorite days of the academic year. The work that you all are doing is so interesting and engaging, and you're so smart, and such great presenters. It's just a real treat. And I do think we should try to find out ways to do this more often at the law school in different areas of law, just sharing our work and really talking about ideas. I always learn so much and I'm just so impressed. So I do think that the presentation part, when we put this certificate together, we were sort of cribbing off a couple of other examples that preceded the creation of this certificate, and that factor made its way in, and it's really quite transformative. I'm really, really glad that it's included, and I congratulations to everyone for completing this great work. Thank you.